people think that name on the birth certificate, well, because they use that name, uh, it somehow has something to do with them, this breathing human, and be like if I wrote if someone wrote smoking baby on a tree or smoking baby on a car. Oh, look, that's my car because it has my name on it. And not just because it has a squiggle that looks like something like your name doesn't mean it's not your name. And the basic issue is an infant was found weighing so many pounds, and an infant is a decedent. You know that you guys are you guys aware of that code section in the Internal Revenue Manual? I guess I'll just go share and show you that code section. Where am I going to share? Am I that prepared? Um, in the Internal Revenue Manual, they have a discussion of what the, let's do the whole whiteboard, high top screen. Derrick, where's that where I can share the whole screen? Show all of them. There we go. I can share the whole screen, can I? Record, new tab. Is anybody there? I just got whiteboard, advanced, allow recording.
Yeah. Shares.
Computer audio, video.
And if you have it open up on your
basic, I thought you could share the entire desktop, so I don't have to worry about toggling. Sorry for the delay. So the basic problem is they don't know you exist and they don't know who you. And as far as XREL this fiction, because they only know what they created, and you only know what you created. I'm getting feedback for some reason, and so your relationship to that fiction is a missing piece. By the presumption of law is that the basic relationship of this entire system of every person out there is a general partnership. And in general partnership, everyone's equally liable for each other's debts. Under maritime law, everyone's liable for each other's debts. And because it's called a joint liability among joint tort feasors. And why is going on? Start here. Oh, that's the problem. I see what the problem is. Sorry, guys. Sorry. I like being smoother than this. I like to be a smoother operator than this. Zoom. Okay, let's just share that thing. Okay. Okay, can you see me? You can see my screen? I'm shrinking people.
Yes.
Okay. We'll find this infant thing. Let's go find this infant stuff. Infant, return from the dead, return from the dead, from the dead. Control. There we go. It's right there. In the Internal Revenue Manual, an infant is a decedent of an estate or grantor, owner or trustor of a trust, guardianship, receivership, or custodianship that has yet to receive an SSN. You realize that infant can occupy any of those capacities. I don't think it's even limited to what they say there. It's an estate, grantor estate, owner, trustor, trust, guardianship, receivership, conservatorship, and it could be all those things. So that's what the infant is. I'm getting feedback.
It ain't me.
Somebody, what's going on? Okay, and here's an interesting piece here. Under the lost at sea laws, when someone gone away from their domicile or wherever they were originally, usually a domicile or reside or habitate. All those words are very different. It says right here, the duties of, in the absence of the real party of interest, trustees administer the estate. This is what they started because that birth certificate's a death certificate. They've been under the birth records when they register at the hospital. And it says, since they've been administering the estate since the moment we popped out, and I'm getting feedback again, so please mute everybody. The duties of such an administrator are similar to those of any other general administrator of an estate, except that in making distribution to those entitled by law to receive the estate or the presumed dead person, he must take from each beneficiary a refunding bond with good and sufficient sureties, conditioned to refund the administrator that the share of the estate received, plus accumulations thereof, in case the presumed dead person reappears and claims the same. And this is from the lost at sea laws in New Jersey back in 1936, when I guess they really talked about stuff back then. The presumption of death in New Jersey. So there's a presumption of death on my certificate of live birth. Let me see, COLB, COLB. On my COLB, where is it? This should be it. Sean Hayes, Hays, Sean. Oh, come on, Sean Hayes. Baptismal certificate. I have two baptismal. I was adopted, so I have two baptismal certificates. Why is my POA? Let's go POA. POA. Attorney. No, COA. Change of address. COA. What's wrong with this? What's wrong with Gmail? It's like they deleted my normal searches. COA, here we go. Send it to Deborah. Bing, 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 bing. I don't want to. Page down. That's just my change of address. COLB. CLB Sean. See, isn't that weird? I type CLB and it comes up with everyone other than the one I want that I've already been. So here's my certificate of live birth. 101 is the tribe number for Alabama. That's the Alabamians under the Census Bureau. 101 is Alabama. 102 is Arizona. And this, I guess I was the 49,021st baby born that year. That's what I think the 49021 is. And so Sean Hayes, not a twin. You have my mom, Betty, the informant, Betty. She informed on me. She already had 3 kids. And then you have, the date of birth up here, 12963 for Sean Hayes over here on the right-hand side. And number 6, you can't see me point. It's where it says male, single, 12963. That's the birth. That's actually a death date. And then you go down. So you have a birth date. You have a Leonard. Leonard is the attendant, and that happened at 2/17, 8 days later. And then you have December 19th down at the bottom, local registrar. There's a registrar at the hospital. Hospitals have a local registrar where all that birthing paperwork, life insurance policies is all at the local level. And so that's why I would start in the administrative process to get your vital records related to a vital event, so you can climb up the chain to get your foundational records. But this record right here, there's, which you'll see on my adopted birth certificate. There's no VS34. The birth certificate is a provisional report of death. A provisional report of death. So you saw the certificate of live birth. I'm going to go now find a birth certificate. Birth certificate. Birth return. Birth certificate. I'll do VS34. VS-34. VS34 has attachment. And E and T. For birth records versus COLB. Name change reasoned. Oh no, that's a different one. Attachment. Derek, did I ever send you my birth certificate by chance?
Sorry.
Say again. Is Derek awake? So this only on my birth certificate does it have VS 34. Appointment to the registrar. This is the appointment to a local registrar and the duties of the registrar. Took me years to track this down. And has all these duties, but let's just jump down to VS 34-34. Control F. Go here. Control F. Is it not here? Have all these forms. Appointment to a local registrar. Oh, sorry, folks. VS 34. Go to the next one. Is that the same one? Still 4 pages. What is going on here? Just look at BS 34 period. Touch this guy. Claim of right. Sorry, folks. I thought somewhere in there I had the full shebang. Is this the full one? There we go. 51 pages. Control F, VS 34. How to complete the provisional report of death. Provisional report of any provisionals that have not been reconciled with the death index report after prescribed review. Look and see if they're really dead. The third month following the date of death, you go down and write up this letter enclosed with the correspondence, the certificate of appointment authorizing you as certificate of appointment to the registrar. Might want to track that down. You as the deputy registrar, vital records with whatever county. In addition, a handout is included completing the duty of the registrar, faculty name. Primarily, your responsibilities are to regulate the process of the provisional report of death. That's your primary duty in your facility. You may find a blank provisional report that may be used when you are off duty. The person responsible for writing the provisionals in your absence should be aware of the procedures and necessary to comply with the law. We go down to the next VS 34. How to complete the provisional report of death. So the birth certificate of live birth is one thing. The birth certificate is a derivative. And so this is how you fill out this provisional report of death. Nothing really astounding in here other than there's a letter they write up to issue, and that's what starts the probate of your birth estate. See page 17. Pronouncement of death. So page 17, order the forms. So the infant is found, and a child is registered. Derek, you went over the child is a child and children are terms of purchase, and then you have and the mom goes home with the baby. You didn't go over birth return at all last night, did you, Derek? Is Derek even listening? Did anybody?
No, we did not.
No. Okay. Let's see if I can find subject BC. I'll show you what so anyone's been adopted, subject BC has attachments. I want you to look at my birth certificate, BC app, BC certs, Aglin in the BC. Okay, here we go. Has the same number, 10163. And they created this after I was adopted. And over here in this little corner right down here, you see right here, right here, that VS34. Took me forever to figure what that was. It's 90 degrees to the print and everything like that. And it's interesting here on the adoption certificate. It says, I hereby certify that the record was prepared on the undersigned and is filed in the Bureau of Statistics at Montgomery, Alabama. Original recording on January 13th, December 9th to January 13th, 1964. And it was done February 3rd, 65. That's when I was adopted. This is when they did the adoption. So this date here is the date the entity, this franchise, this all caps name, this Sean Scott Haggerty person, is a federal franchise. And we know it's a federal franchise because on the back of the birth certificates, 205 fiduciary, over here, says this certificate, it's a birth certificate. You can kind of read through it if it came through better. This certificate of birth should be carefully preserved as a record of value. A record of value. Strange language, record of value for future use. And it's going to be used to establish the age to enter school, establish the age when applying for working papers, to establish legal age for rights of franchise, for jury or military service, proving citizenship, obtain passports for travel in foreign countries, and to prove right to inheritance of property. If any errors are found in the statements given on the face of the certificate, kindly send correspondence to Mr. Herman Bunsden. I actually looked him up; he was real. I found him mentioned in the newspaper from back then over in Chicago. So that birth registration that happened at the local registrar on December 19th for me. So birth registration, local registrar. Oh, COA. Let's go back to COA. COA. Change of address. Why is it so strange? Subject. Usually it goes to the last one. So there's that one. We just saw that this franchise piece. What threw me off at the beginning, I did a change of address from 6801 Airport Boulevard. That's Providence Hospital where I was born. That's noted on my birth certificate. And I changed it, business name Sean Scott Haggerty, from the Mobile, from the hospital where I was born as Sean Hayes, to my address back then when I was in California. Because this change of address is not, they don't give you a receipt when you turn in a postal change of address. I went ahead and did a true and accurate copy of what I was going to hand to the clerk. And then when I did hand this change of address that the picture of you see, I had the clerk stamp it. She stamped it no problem as a receipt. And what came back, these came back on the same day. I got this white envelope, official change of address confirmation, just addressed to Sean Scott Haggerty. This is how it came from my adoptive name. Of course, my name didn't exist down there when I was born down in Mobile, Alabama. But then I also did one for the birth name, Sean Hayes, same address, same information other than the business name. I did the start date 7/22/17. This, by the way, was when the eclipse was happening last time in 2017. This was the eclipse day. It just so happens. And so got that stamped. And this is I mailed both these, turned in both these changes of addresses on the same day at the same post office. And they came on, both these envelopes came back on the same day, but different envelopes. You know the logistics involved in doing different envelopes? This kind of a change of address goes to this envelope. This kind of change of address goes to that envelope, especially coming from the post office. They have a hard time. They lose 8 million pieces of mail or more every year anyway. But it came back with this president right here, President Sean Hayes. And it took me forever. Okay, president of what? What president of what? Until I found that back of that birth certificate in 1940, where it said rights to franchise. I'm as a president of that federal franchise. Because with that, the birth certificate that's issued by the president, right? The president's the power of attorney. It's also a stock certificate, but it also creates a federal franchise. And I acknowledged and accepted the presidency of that franchise as well. Because if someone goes to jail, they're disenfranchised, right? They can't vote. They can't have a gun. Well, they're not supposed to have a gun, and so you can't leave. Sometimes you can't leave the country. Moral turpitude. You can't get a name change if there's any charge of moral turpitude. So certain things they can control certain things in the system because it's federal franchise, and of course the birth certificates became mandatory. Um, the Townsend Act in 1912, I believe it was 1912, is when they started doing this birth registration. Before then, only slaves had birth certificates, and only slaves needed marriage licenses to get married, uh, um, which is interesting. But after the bankruptcy, they started issuing birth certificates for everybody, even retroactively. I've gone back to 1905 when my great great grandfather came over from Ireland, and they took his information from Ireland and actually made a birth certificate here for him as well. So the birth certificates were brought forward for people who were pre 33, and so this, in order for the federal government, once the federal government went bankrupt, an insolvent thing, first of all, has no money, and number two, an insolvent thing can't sue anybody either. A bankrupt cannot sue somebody because they have no risk. They have no ability to absorb any risk because they're bankrupt. So the federal government, in order to extend its control, they created these little franchises, these federal franchises, and had everyone start using that franchise name and identifying themselves with this birth certificate, franchise certificate, and even use the franchise certificate to attach to the SSI to get that IMF account, which we talked about last night, the IMF account, that Social Security account, IMF being the UN. Did you guys watch that ESF, the Exchange Stabilization Fund, by any chance? It's just interesting how it came about. So this way, if Papa John's, who I don't like their pizza, it's just kind of well known. If Papa John's franchise at the top were to change the menu, change the uniform, change the prices, it would trickle down from the top headquarters, and all the little franchisees would have to then change their menu and change the prices and change their little uniform they run around, because the top franchise has that kind of control to dictate what goes on in the little franchisees. And of course, the franchisees have to pay a kickback tax, a franchise fee, which is a kickback tax, back to the parent franchise. So this is my opinion of how the federal government set up after the bankruptcy to extend control after the bankruptcy. Hope that makes sense. I'm not watching the comments. If anyone, Teresa, if you could, and let me know if anyone has any burning questions. So this is the change of address done, and when this confirmation comes in, on this president one I got, I had to go take it back into the post office. Derrick's been doing his, and they've changed the change of address form with the post office, and he's been going back in, and there's a little barcode, and he goes back in only from the certain location. I think the Denver location. Other change of address confirmations come in. They don't need to be scanned in. Some of them do need to be scanned in to actually confirm it, which is kind of interesting. So, the birth registration
that's why he has his answering machine. You've reached the president of the United States.
Maybe I'm not sure. I'm not sure what the real motive behind that is. Maybe freak people out. So we have this franchise certificate. So this is the child, and of course the child's name is Sean Hayes. That's the child's name, and a child's a term of purchase. So when people think, oh, they committed fraud, that birth certificate, people start identifying. You guys hear that out there? People saying the birth certificate is a fraud, and they've registered you, and they're committing fraud against you because of the birth certificate. It's silly, because it has nothing to do with a human being. They didn't register the human being; they registered their birth event. An event happened, and all they're doing is registering an event that happened at a hospital. All hospitals are under the Templars, the house. Part of the Templar, part of the Jesuit military, and it's also under the military, because doctor is a military rank, a military status. Being a doctor is a military rank. Doctors can kill you. A physician can't kill you, but a doctor can kill you. And so a patient, if you go to the hospital, you don't write on top of all that paperwork, doctor means physician. And the word patient, the legal definition of patient is a mental incompetent subject to medical care with or without their consent. So so where it says patient, you put client. And anywhere when there's a signature line that says patient, you cross it out and you put client. And every patient have doctor means physician and patient means client, just so they can't hold you there because you're mentally incompetent and do whatever the fuck they want to do with you, including kill you if it's a doctor. I'll post in the room towards the end. There are two Hippocratic oaths. There's two of them, one for a doctor and one for a physician. And if you address the physician as a physician and mention his physician's oath, she will did this. She-Wolf did this, and his demeanor, the doctor's now physician's demeanor, completely changed. It was not. There were not interrogations. He was more facilitative. It was a completely different interaction with the physician than it is with the doctor. And for any paperwork that I would sign at the hospital, because of the person there, I would write property of the state of Alabama 10163 and that birth certificate number, and I would put by Sestui. I would put Sestui. The difference between Sestui and beneficiary. The beneficiary has to pay tax. If I put $1,000 into an account into a trust for Derrick, and Derrick gets that $1,000, that's a taxable event.
Excuse me.
However, under the
Excuse me.
SETI-KV Act,
Up, brother. You broke. Could you say that again, please? Something about the Sestui?
okay, so under the SETI-KV Act, you heard the trust. So if there's a distribution from a trust, the distribution is a taxable event. But for the Sestui, the SETI-KV Act, Sestui Act, which the Supreme Court rules on, the taxpayer is the SETI-K trust, and the taxpayer is the trust. So that's the interesting thing. So this SETI-K trust, for there to be a SETI-K trust, there must be a SETI-K estate, and for the SETI-K estate, there must be a SETI-K use, USE. And for the SETI-K use, SETI-K estate, and SETI-K trust, there must be a Sestui. The Sestui, if anything that comes out of my SETI-K trust or comes down to me through the SETI-K use for the Sestui, they can't tax me on whatever the distributions are because everything held in the SETI-K trust is my property. So they can't tax me by giving back my property. Remember that in the very beginning, the duties of the administrator is the same as any other administrator, except that when there's a distribution to the estate, to those lawfully authorized to receive it, must provide a refunding bond to indemnify in case the presumed dead person comes back and is in fact alive. So they have to go out and invest out everything they're doing with our SETI-K estate, because when I come back and prove in fact that I am alive, well, now the distributions come back to me, but they can't tax me on it because it's mine, because the money you make off my money is my money. Anything they've done with this investment, I can't be taxed. Why? Because it was mine to begin with. Just because you make money on my money doesn't mean you get to keep my money, because it's mine. So there's no tax for the Sestui. And someone in the W-4 group actually signed their W-4s as Sestui. And the IRS wrote back and they addressed him not as taxpayer. It said, "Dear Sestui." The IRS said, "Dear Sestui." So if you want to change the status for the IRS, sign any documents you do with the IRS as Sestui.
Excuse me, Smoking, could you pause for just one second? I'm gonna go ahead and start
Start and stop.
stop the recording, start again.
You know, do a
Okay,
jumping jack.
I'm gonna
Do some
stop.
jumping jacks. What was I gonna say?
Wait a
My
second here.
Sestui.
Okay.
Oh,
Oh, now could you spell that Setisu or Setisu? Is it Sestisui?
it's on the screen. Cestui.
Oh yeah.
So here's an interesting.
Setisu, yep, you just pronounced it different. Yep. Okay.
Wouldn't you like to do this? Sestui. control of the legal estate. Yeah, I do. So it goes down here. Settlement of trustees' accounts. And probably all states are statutes requiring trustees, as well as I'm getting feedback or sound from somebody, as well as other fiduciaries to make. Who's 1920? Would you please? Who's 1920? Okay, good. No, somebody else is 19. Who is 1920? Someone take care of that. How do you guys come in here and do this? Like you're new or something. Can someone mute 1920? Teresa?
Derrick made you the host. He's gonna try to request being the host again so he can.
Well, I'm just.
Yeah, go ahead and make
just-
me the host, Sean. I'll keep. It just works better that way. You can flow, brother. Because there's nothing worse than getting into a flow and a groove and getting interrupted, and then the train of thought gets lost, the message gets diluted, and it's absolutely fucking horrible. So we've
Yeah,
got a tentative bunch here that are
becomes
executing
retarded, Bill.
processes, and we want to give them the most
Clean.
correct education they can get without being interrupted or distracted one way or the other.
How do I give that to you? I don't know.
You're gonna go down to participants and click the three little dots by my name, and you're gonna make me the host again.
Okay. Host, just make host.
Okay, really
Yes.
quick, smoking baby. I'm
Mhm.
gonna when I see the questions in the chat, I'm gonna you in a private message so that when you want to pause, you can just read through the questions that way. Does that work?
You want me to read through the questions?
Okay,
what you said?
fine, never mind.
Okay.
About to drive over there.
So 920.
Hands and legs in the car.
Hmm?
Hands and legs in the car.
Okay. Okay, George. Just want to make sure everyone's muted. It's 920 person. Yeah, 5308.
What?
Please mute your phone. Please mute your mic.
I don't know how to mute it.
On your phone?
Yeah.
Are you on a landline or you on a cell phone?
No, I'm on the cell phone just in case if the computer crashes.
In the cell phone, there's a little mic you push on the face where you're looking at the screen. You can, with all the numbers, it has start, stop, the green and the red, and there's a little microphone. You can just touch the microphone.
She muted out.
Okay, good. So right here, beneficiaries control of the legal estate. Cestuaries control of the legal estate. It's important to observe that while the legal estate is in the trustee, yet, unless it would clearly defeat the plain intention of the trust instrument, the beneficiary, if sui juris and sole beneficial owner, cestui, has in equity complete control not only of the trust itself, but of the title as well. That is to say, the trustee may be required by the cestui to make such conveyance of the legal title as the latter may direct, the cestui may direct, and even a conveyance of the conveyance to the cestui himself, thus putting an end to the trust. So I refer to myself as sui juris, sole beneficial owner, cestui. Does that make sense? As part of the scribble line. For example, A to B in trust for B, passive trust. Here B is sui juris and may end the trust at his own discretion. Or again, A to B for the A in trust for B for life, remainder to C. I did this on my power of attorney. This little line here. C then purchases B's life estate, being now complete owner over the equitable title. C may end the trust at pleasure by requiring the legal title to be conveyed to him, C. So when the trust has, oh God, can you hear that in the background?
There's nobody unmuted but you, brother.
No, but can you hear these kids in these old electric cars rolling around the street?
No.
Okay. So where the trust has legal So where the trust has, from any cause, come to has the legal title to convey to him. So where the trust has, from any cause, come to an end, the beneficial owner is entitled to the conveyance of or release of the legal title as by the trustee. On the other hand, when the cestuees, plural, or some of them are not sui juris, or where the instrument vests at discretion in the trustee an active trust, which would defeat the which would be defeated by permitting the cestuee to control the title, then the control will not be permitted. See, so I'm the cestuee. I'm claiming in my document cestuee sole beneficial owner as cestuee is what I'm putting in my documents that I'm preparing because I'm going to go down to probate. I hope you guys find this
Sui
interesting.
juris is by one's own right, meaning exhibiting and exercising your sovereignty.
There's another little interesting phrase.
Cestuee is because there's a Cestui trust, which is your Social Security juristic person, which is a United States citizen and is also a taxpayer. The Social Security Administration account is where the credits flow from by the authorization of the cestuee, who has the beneficial right of use and can compel the distribution of the credits.
We have to give them instructions. And when we give instructions,
Also,
we
too,
need, go ahead.
yeah, exactly.
Also,
Also,
too,
remember, I sent you 12,400 and 12,408 of the California probate code, which seems to me like this would fall right in that category.
12,400 of what?
California probate code. Remember, we were having that discussion about finding the cross statutes.
Wasn't it 72,400? Wasn't it 72,400?
Well, it's 17,400, but in 12,400 and 12,408 talks about if the man shows up, he's entitled to the proceeds of the state. I'll post it in the chat. I'll find it and get it when I have a chance. I'm recording, so I can't access it now, but I'll get it.
And I want to point something out to everybody, because there are a lot of people that are holding educational seminars and helping people, and their intent is pure. But what they don't understand is they say, they're naysayers that say, don't study the statutes, codes, city ordinances, rules, and regulations. Don't use them. It makes you subject to it. Let me tell you something right now. The only thing agents and agency are bound to and understand is statutes, codes, city ordinances, rules, and regulations. If you're not showing them statutorily what you're talking about, they will say, we don't understand. We can't compute what you're trying to convey. Okay. Nothing that you're stating to us, it's all foreign, and therefore we don't understand. We can't comprehend. We have a language barrier. So this is why we study the statutes, codes, city ordinances, rules, and regulations. And we also study the private side and trust law, so that when we want to communicate with these agents and agency, we can show them where statutorily it's provided that they need to do, or they're compelled to do exactly what we're asking of them. It's not that we're subject to the statutes, codes, city ordinances, rules, and regulations. It's just the instructions that they are bound by, and how you can enforce them to move, because they're already in agreement. It's their own code. So it goes back to Jesus saying, aren't your laws the same as my father's? And they were like, well, damn, we can't argue with him now. I mean, he's got us lock, stock, and barrel. He's saying God's law is the same as our law, and we mirror God's law. So when they were challenging Jesus Christ, and he would say, well, aren't your laws the same as my father's? And then there was no argument. And if their laws weren't the same as his father's, then they were outside of the law, weren't they? All right. So I yield. I just wanted to help you guys understand that, why we're studying statutes, codes, city ordinances, rules, and regulations. It's not because we're bound by them. It's because that's how we have to communicate with them. Because otherwise, if you communicate with them in a normal fashion, they will say, we cannot compute. It does not register. We have a language barrier. We're not understanding what you're wanting done. You have to show us statutorily what you're.
Yep, laws of agency, which the pastor's going over or has gone over pretty well. Laws of agency, yep.
Here's another little ditty. Here's another little ditty. I'm competent to handle my affairs. Likely the two most important concepts of legal fiction system of all corporations, such as the United States Inc. and the phrase "I'm competent to handle my own affairs." I'm competent to handle my own affairs, and their meaning being authorized, and the meaning of being authorized representative in accord with 3-402. These two concepts are key in overstanding, I can't stand that, comprehending what the legal system is doing to us and exposes the fraud slavery of the bar attorneys system was across the earth. I'm competent to handle my own affairs. The one speaking who come handle my affairs is declaring legally competent. Without that phrase, bar attorneys worldwide are legally we are legally incompetent and can and should be treated by them as such. Does that make sense? So that's just an interesting ditty that popped up. I can post this in the room. So now I'm going to go back to I was talking about custody control of the legal estate to be sui juris and sole beneficial owner, and coupling with this I'm competent to handle my own affairs are interesting little tidbits. All the jots and diddles they want to play with. There you go. These cats are driving me crazy. So do we try to pick up where I left off? So we have the infant that was found, who could be any of those capacities. The infant can occupy any of those capacities. And then you have the birth certificate, which is a death certificate on probate. They've been probating all along, especially under the lost at sea laws we read for New Jersey in 1936. And then you have the baby, and the baby runs around using that dead fiction name. And I wrote off to the Secretary of State of Alabama and asked her a question. Let me find it real quick. Secretary of State, Alabama, SOS. Secretary of State. Secretary, Alabama. Alabama Executive Control from the clerk. Email from the clerk of probate, Mobile, Alabama. What's this say? I wrote up to the Secretary of State in Alabama, and I asked her about when the entity comes into existence. Essentially, has a essentially its birth date. I put birth date here. Birth date. And a mystery. Date of birth. Sorry for the province to release my abstract of vital records. Good afternoon. Pamela Boyce. So I wrote a letter saying like a partnership exists on when the partnership documents agreement is signed. Another time, an entity only exists after a registered agent is a registered agent. I have two different emails, so I'm trying to think. Baby patients, smoking baby, SF95. Let's go here. Registered agent. Florida registered agent registration. Alabama agent. Okay. Sorry, I'm not as prepared. I was rushing to get here. So what the Secretary of State wrote back and said, the entity does not exist until it's registered at the Vital Records main office. So that date on the birth certificate, on my adoptive birth certificate, where it showed the was on about 13th of January. That's when that all caps person came into existence. So that January 13th, 1964 is when that all caps name actually came into existence. So the trick that happens is when we use our live birth date, certificate of live birth date, coupled with that dead fiction name, it creates a general partnership. So by going into a court case and bringing in proof that the actual birth date for that all caps fiction name is this January 13th, 1964, the case gets shut down. It cuts me loose because now there's no joinder between the living and the dead. People have done it, gone and changed it to this original recording date, and it puts a nix on the case. And there's a recording I recorded. It was off TikTok. And a man went in to do his sign up for his 62 to get his Social Security benefits, and they started going over this original recording date versus the birth date. And the girl he was talking to went back, talked to the manager, said, "Okay, you're perfectly correct." And they went ahead and provided him his benefits. But I suspect if ever there was some kind of levy or fee or something like that, they wouldn't be able to go and tap into those benefits because of the separation of the living birth date compared to the franchise existence date when it came into being. So that's something to consider when you look at your SS5FS. There's two birth dates. There's a birth date on box number 4, and there's another birth date down in box 13. And I haven't quite figured out how I'm going to thread the needle. Do I qualify the one at number 13 being the living date and box, and have them check, because they didn't want to change. They didn't want to change when I went in and did my name change to a first middle name in the first name field and surname in the last name field. He wouldn't let me change the birth date to this for this all caps person, Social Security person, to January 13th. So this other guy went into the Social Security Administration, and for me, it's the joinder. If I run around using this all caps name, then I become general partner for that all caps name that's on the driver's license, and now I become liable to help pay the debts for that all caps name, just like any other general partnership is. Does that make sense? Am I saying it correctly, Derrick? I just need feedback to see if I'm on the right track.
Well, that brings up a very interesting thought. Instead of going to get you to be the surety on these charges that they create, when you flip it and bring on that date, it went into the county registrars, which is usually under Truth in Lending Regulation Z, minimum 72 hours. But I've seen them like yours. You were born on 12/9, it went in 12/17, and on January 13. So instead of going in and having the party, the co-partnership pay the fines and fees, they may be pulling them out of the comprehensive annual financial reports that have been set aside for this estate, that instead of opening up a probate, they're now just going to draw those funds directly from the capper account. Just a thought. I'll
For California, in order to get your registration date, maybe it works in the other states as well. According to the instructions, when you do the application for the birth certificate, you need to write around the edges, confidential copy requested, confident all around the borders, 90 degrees on the sides and everything. You have to write confidential copy requested. And because other birth certificates, when people get them, that little area where it has that little stamp in there, hereby certified for going for January 13th, that's usually blacked out. They keep that blacked out. So you have to request it specifically, a confidential copy. And that's how California will add the original recording date to the bottom of the birth certificate. A friend of mine in California did that. So you guys might consider the same thing, or go look in your birth certificate rules, regulations, or call them up and ask them how you get the restricted copy or the confidential copy. And that's the significance of having that original recording date. So yeah, so in order to not be general partner with it, and which is the presumption under admiralty, it's called the general liability among joint tortfeasors. Who carries the primary active degree of fault, which you heard Derrick talk about. And Derrick loves doing that because it freaks the hell out. they like gulp a little bit with who carries the primary active degree of fault. So we have to. So now we have to create a relationship.
Could you say that again? Could you say that? Could you say that again, just a little bit slower, please, Smoking?
Sure. It's called the Google Blue Sky Laws. Blue Sky Laws. Blue Sky Laws.
Okay.
By state. And Blue Sky Laws. It's interesting. So when it comes down to general liability, yeah, ability among joint tortfeasors. Several liability among joint tortfeasors. Joint and several liability is a rule followed in some states in which two or more parties may be held independently liable for all the full amount of the personal injury plaintiff's damages, regardless of the prospective degree of fault. The parties are found responsible for the accident. And it's also called the primary active degree of fault. Fault in civil law, evaluating the degree of fault of negligence of the individual parties. Under maritime law, until they can't go after the other participants in the maritime venture until the assets of the party having the primary active degree of fault are depleted, and then they can start going after the other parties to the vessel, throwing cargo overboard and stuff like that. If there's some kind of venture that's shared among the people, all the parties involved in that maritime venture, it's shared among them generally. That's why general partnership is the default status among parties, because it's the easiest way to distribute liability. Florida's a no-fault state. California, I believe it's California. Is California comparative fault? I can't remember. And even some states during a divorce, some states are no fault, and other states, if whoever breaches the contract first doesn't get as much in other divorce states, because a marriage license is just a merger of two estates. It's kind of a maritime thing, and of course the state's the parent in the middle, and I would say that the state carries the primary active degree of fault for that contract because they don't get full disclosure, number one. And there's one other thing it's called Tulane.
I want to be real clear.
Contribution.
When you're speaking of failure to provide full disclosure, it would be also failure to disclose a material fact. When you're bringing claim for failure to provide full disclosure, you also want to use the failure to disclose a material fact, and which is a violation of due process of law. And as such, any contractual nexus that may have been created via the actions is void in ab initio non pro tunc for the failure to disclose the legal consequences of entering into said agreement.
So this is where insurance comes from. That's why everything's insurance, because maritime law came onto the land. Indemnity contribution. So indemnification indemnification is an extreme form of contribution, and contribution is an extreme form of indemnification. You can read about it in here. And so realize under the lost at sea laws, it comes down to they have to do a refunding bond to indemnify the trustee doing the distributions in case the real party comes back and is in fact alive and can be made whole. Because that's when the land comes back. The land comes back, and now the real owner has to be made whole. If you look in the CAFR funds, if you spend a Friday night or Saturday night looking through CAFR funds, you'll see that there is a portion in the CAFR funds where they have refunding bonds inside these CAFR reports. So something's going on.
By the way,
taking out
did
refunding
you hear what I said did you hear what I said in regards to the birth date when you brought the different birth date up in a court scenario, how instead of getting the man there become surety for it, now the liability switches from the man being the surety to it going to the comprehensive annual financial funds based upon that area. You heard what I said. Okay, thank you. Okay.
Yeah, I got a ticket driving. I manage an estate, and I have the estate car, drive around it or travel around it, and the tags were out, and the insurance wasn't with the car, so I got a ticket, and had a fun time talking to these young kid cops, and so he said, well, you have 4 ways to take care of this, blah 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 blah. I said, well, there's a 5th way. He says the driver's license was issued by the Secretary of State, licensing that Social Security name and number and its incompetence to engage in commercial use of the public roads for private gain. So since the Secretary of State created it, the Secretary of State's liable for it, just like the dog owner is responsible for who the dog bites. I don't have the liability. I'm just the agent of service of process, which is true. So I'm debating how I'm going to handle this traffic ticket. I'm thinking about endorsing it for $5 million and having it deposited with a special restrictive endorsement. I haven't figured it out yet how I'm actually going to sign it. And because in the signature box, you realize in the signature box you don't really have to sign it because there's already an X. It's already pre-signed, and in the X section it says government ID. They just put it just says government ID is what they had pre-typed next to the X. And so I can't decide if I'm going to take that traffic ticket, put it in the disputed ownership fund as an escrow account, and then rack up $5 million in the escrow account and just try to tap into the escrow account. I'll let you know how it goes later on down the line. Right now we're a little off track. But because the birth certificate is tied to the Social Security card, and the Social Security number is tied to the estate, we found out that the Social Security card was tied to the estate back in 2015 when a friend of mine down over in Texas had filled out a IRS form 7050. Control T. Get out of here. Control T. IRS form, Google. IRS form 7004. Extension for time to file form. He filled out this form here. Business and income tax, and he would write up here. We would write smoking baby. Come on, get my fingers on the key. Smoking Rex baby. By baby, comma, 4 spaces. Smoking Rex as executor. And you put in the SSN. I haven't tried this yet. I think about, yeah, it says identifying number, right? Which is interesting. It doesn't say social security number, it doesn't say EIN number. I suppose you could put the 10163, 101-63-0722298, the birth certificate number, into that identifying number as well. I have to take out the dashes. Sorry, the dashes don't work in here. But there's enough room for all of them. 072298. Look at that. Somehow my birth certificate number fits perfectly in that identifying number, which is interesting. So because we're doing an executor, you have right here an estate other than bankruptcy. You put a 04, 0 tab 4 in there, and then Of course, you put the address and everything like normal up there. If the organization is a foreign corporation, no, we're actually doing 04. We're doing an estate, so it's not a corporation. We only have to read that far into it. Check this box. If it's a foreign corporation, check here. If the organization is a corporation, check here. If the organization is a corporation or partnership, check there. So we're not checking 2, 3, or 4. And then it says down here, number 5, if the application's for a calendar year or a tax year beginning whatever. So you would, so I would put 24 here for the year 24 because I just use normal years. I don't do the government, like the government's October 1st to September 30th. And it's short year. If the tax year is less than 12 months, is there ever a day in a year where we're less than 12 months? Maybe on January 1st, which is a holiday. But so if it's less than 12 months, the tax year or the tax year, if the tax year is 24, if the application is for calendar year 2024 or a tax year beginning, if the tax year is less than 12 months, check the reason. So it's less than 12 months. It's less than 12 months on January 2nd. You would put an initial return. And then down here, tentative tax. People go, what do I put there? I go, well, what would you like? How much tax would you like? I go 0. So you go 0, 0. Total payments and credits, 0, 0, 0. And then balance sheet, 0, 0, 0. And you send it in. And when you send this in, they send you a CP 575, and I think it's a G, non-taxable, and it starts with a 90-6. So it could be a 91-6 at this point. So my friend filled this out, and he got a letter back from the IRS saying, you know, smoking Rex baby, estate, and then it had baby comma smoking Rex as executor. So my friend had the status of executor next to him, EX. But he just had smoking Rex baby was the name of the entity with a 90-6 number for the estate. Then we went into probate over in Grayson County to record his power of attorney, which we're getting to. We had to record the power of attorney. So he walked in there, talked to this woman, tell her that he needed to record this power. What was he? Record the power of attorney. And she said, well, you have to be an attorney. He says, well, I'm the attorney right here. She says, well, I think you have to be a real attorney. And I'm standing next to him to the right. He's 6'2", I'm 5'9". And I said, statute code and regulation under my breath. He says, well, do you have the statute code and regulation where you get that requirement? She sighed forlornly, trundled off, and came back later. Okay, we're going to record it. And he says, you can step next door to go and the judge will call you forward. And I was looking. It took about 10 minutes for her to do it. And I'm looking all this. If you go to the probate, there were boats for $240. There's all kinds of stuff for sale for $240 in the probate court. All kinds of stuff for sale. And so he comes up. I'm standing there looking at this boat for $240, and I hear someone hyperventilating. So I look up to my right, and there's Kevin hyperventilating. And I say, I go, what's wrong? He goes, I'm scared. I go, what? You mean to tell me you've been to war 4 times, you went to the Air Force Academy, then you went to pilot training, and then you went to the Gulf War, and then you got married, and now you're scared? He goes, yeah. I said, well, what are we here for? He says, I don't remember. He says, well, what do you
See, the man
what
was.
would you like to know? Huh? Say what? So I said, says, what do you like to know? What the rights, title, interests, duties, and obligations of the issuer of the certificate owes to the owner of the certificate? I saw him close his eyes, and he started moving his lips, memorizing the words that I said. Said it at the academy. You had to remember everything. You had to know all the menus, all the movies, everyone's name, their birth dates, and all the. We had to know all this stuff going to the Air Force Academy. That's where I know him from. And so I could tell he was memorizing it because he was my freshman as a senior, and I could tell what he was just talking out of his head. So he was just sitting there memorizing it in his head. And I said, Kevin, You can't speak out of your head. You have to show conviction when you do this. Otherwise, you'll see right through it that you're just memorizing something. You really don't have the conviction to do it. So do this with your left hand. Go. I'm here for a determination on the rights, title, interest, duties, and obligations of the owner of the certificate. Those are all tomahawk chalks. Rights, title, interest, duties, and obligations of the owner of the certificate, of the issuer of the certificate, with his right hand to the owner of the certificate, doing the tomahawk chalk with his right hand. So we went through this practice of moving the hands around, and then walked around, and then before we went into the probate's office again, probate court, he said, "Okay, what are we here for?" And he had paperwork in his right hand with that CP 575 and a copy of the birth certificate. And he said, he did a tomahawk chart. Rights, title, interest, duties, and obligations of the issuer of the certificate owes to the owner of the certificate. And I said, great. So we went in there, sat down. If you really want to see how people screw up their lives after they die, go to probate court where they haven't appointed it. They don't have a living will. They don't have any guardians ad litem set up. And it's just a freaking nightmare when people die without telling everyone what to do with all their stuff. And there's a guy had died. He had a son that had Down syndrome. And they had a
Hey,
guardian
smoking baby, your voice keeps going in and out. Are you moving around, or is your microphone
no.
batteries or something
Is it
going
better
on?
now?
There you go.
No, is it better now?
Yeah.
Hmm.
I just didn't know if you're on a headset and the battery's going dead, but you're fading in and out, so we're missing part of what you're saying.
Okay, so what was the last? Where did it fade
We're
out?
talking about the rights, titles, duties, and obligations, and he was doing the tomahawk with his hand,
Okay.
talking to the judge.
And so if you want to see how what happens when people don't take care of their estate while they're living, a man had died. And he had a son with Down syndrome. He didn't have any type of plan for the son, and so they had a guardian ad litem. There's some woman sitting in the front seat, I guess was a friend of the family, chewing gum, smacking gum in the courtroom, chomp, 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 slouched over in the pew, and I just look at this nightmare going on. They're trying to figure out what to do and everything. And I told Kevin, this is a good example that to have our stuff tied up before we're dead. He goes, yeah, I agree with you. Finally, they got done, and I just share that story to go see the nightmares that happen when people die in intestate and they have liabilities and stuff. It's just a nightmare. And then another lawyer comes in with a stack of boxes on a dolly rolling into the probate court. And the judge looks up, and we're the only people we're on the right side of on the pews. He looks up and he says, "Oh, can I help you, fellas?" And Kevin goes, "Sure." Kevin the table and stands right before the podium. And the judge motions to me, "You can come up too." He says, "I have no interest in this, Your Honor." He says, "Okay." And the judge looked at Kevin. They're eye to eye because Kevin's 6'2", and he's looking directly at the judge sitting up there on his dais. And he says, how can I help you today?" He says, "Well, I'm here to get a determined on the rights, title, and interests, duties, and obligations of the issuer of the certificate to the owner of the certificate." The judge says, "What certificate?" He says, he was going to say my birth certificate. He said, I mean the birth certificate. I got to him on these pronoun trouble, this pronoun trouble that I'm on everybody about. He says, the birth certificate. The judge says, "Well, I believe the secretary just has to maintain a record of the certificate." And he says, "I'm not even sure if I'm allowed to make a ruling on it, but you can bring up an order and we can consider it." And he said, and he's looking at the clerk that had forlornly sighed. She was standing to the judge's left, Kevin's right. And she's looking at the clerk, and she has her fingers together like Nosferatu, like the little minion for the vampire always has a little gremlin next to her. And she's like, has all her fingers tips together. Yes, 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 yes. And he's looking at her, and he's looking back, and he's all calm and everything like that. And then he swings around in the chair, and he looks directly at Kevin's face. And he says, do you have a driver's license?" And Kevin takes a full breath, going up to his full 6'2", 2.5, 3. Tall people like to slouch, I guess, to fit in with us people who aren't that tall. He takes a full breath, and he goes, "Yes, I do." He says, "Do you have insurance?" "Yes, I do." And he says, "Do you deny having a social security number?" And I sat in the pew and I went, holy shit, I don't have an answer for this. I'm freaking out in my brain. I don't know what to answer. But because Kevin had done this 7004, and over here in the identifying number, he had put his birth certificate, 1, 2, 3, 4, 5, 6, 7, 8, 9. And he got that CP 575 for the estate as the executor. Because that was a fact in his head, Kevin held up his paperwork in his right hand, and he said, the social security number pointing to the sky is tied, pointing straight ahead. So he punched his hand towards the sky. The social security number punching the sky is tied, punching straight forward to the estate, punching down with a paperwork in his head. And it's like someone put a cattle prod on the judge's pucker on his chair. He lurched up in his chair and he said, well, okay then. Well, okay then, you just go ahead and bring in the order and we'll record it. And he's looking at the clerk again. And she's going, yes, master, yes. And she's shaking her head like a little gremlin. Yes. And the judge said, Kevin said, well, what kind of order? It says, well, if you go talk to the girls down at down to the library downstairs, I'm sure they have some examples that they can share with you. And so we left and walked down to the library. He talked to the librarian so that the judge sent them down about some orders for the administration of the estate, and he never followed through after that because his wife was all scared. He didn't follow through. He didn't follow through in 2015 to get administration of the estate or whatever he would be asking for.
Oh my God.
And I know. So the social security number is tied to the estate. We know that for a fact. So the question is, out here in the normal world, not so much in equity and probate as the executor, the executor can't really appear in public because the executor only has status in chambers, and the lawyers come in to chambers, they become a trustee. The lawyers become a trustee inside chambers, and Derrick has a thing about Vince Vaughn. Had a thing when he was in chambers, and he told the lawyers to shut up and get out. And so so out here in the normal realm, when it comes down to that all caps name, which is a federal franchise name, even though I'm the president, what's my relationship to that all caps name? And that they recognize, because people go in there with that executor letter, they go into court, or the executor letter, which I don't think is very wise. Not to mention, what can the executor do? Can the executor do subpoenas? Can the executor command things? Can the executor do things out there in the public-private venue side? So the office of attorney, in fact, is an office they recognize, and it's even in Gibson, office of affidavit in Gibson's book. Affidavits are not part of the court record, even if filed, unless made so by a bill of exceptions or by an order of the minutes of the nature of the bill of exceptions. So there's an office of attorney, in fact, that's recognized by the court. And so now we're gonna shrink this down a little bit so I can get to my tabs. How can I make this? How can I resize this thing? Let's go over to uniformlaws.org. CFR, California Power of Attorney, statutes of regulations, trade or business scam, SSA, 363. Okay, I just open one. Uniformlaws.org. This is where I started. If you go into your uniformlaws.org, and they have transfer on death clause for minors. There's all kinds of uniform laws in the United States. So we're going to do a power of attorney, Control A, power of attorney. E1, power of attorney. Power of Attorney Act. Comes up with all I like the old one better. They did this whole glitzy thing, making anything else flashy. So here's the states. Introduced is green, enacted is blue, is that sky blue. Prior version enacted is the maroon. So if you go to your states, You go to your different states, you can see which ones are done. Like I'm Alabama. The prior version was enacted in Alabama and has all this information down here. And you can
You're on Mississippi.
go to your particular states and what? So the
You had
states
your
that
arrow over Mississippi. I'm sorry. You had your arrow over Mississippi. I'm sorry.
yeah, so that was enacted. So Florida hasn't done it. California, they say the prior one was enacted, but California has some additional pieces in there, just like Florida has additional pieces in there. And so this is how you can go see whether or not you're. If you scroll down here, you can actually get the actual documents down here. You can actually go. Where is it? Where's the actual kit? Here's the kit. Final act down here. You can download the final act and go read through it. Let's see what this one looks like. Download all AUPA, Word doc. Let's see what it looks like. Uniform Power of Attorney Act, kick out. National Conference on Commissioners of Uniform Law States. There's all kinds of good stuff in this light. At least I think it's cool. See how it looks in here. Short title definitions, authority. I'm just scrolling real quick to see if they've changed the format from what it was for the previous one. Overview. Wow. Yeah, so it's double spaced. These things are double spaced. It comes up with all these definitions, durable. With respect to power of attorney means not terminated. So by default, the these power of attorneys are durable by nature unless you limit it. In other, I think they mentioned here, in other places, if it's not uniform, then you have to specifically state this the authority is not terminated by either incapacity or incapacity relates to disability. We have to specifically state that it's not impaired by the incapacity or disability of the principal. By default, it's durable under the uniform laws. So the one I like working with is Alabama's. This is probably just as good. Let me find Alabama's. The Alabama Uniform Power of Attorney Act. It's in Mississippi because they used to be the same territory. And most of it's double space. What's good about it is you saw in the other one, there's commentary. The commentary tells you the whys, wherefore, how comes, why to, why nots. For instance, if we look up donee, you have the principal donee, and you have the principal donor, and you have the agent donee. So the donee is the agent. Exercise power of attorney has manifested the tentative draft and noting that unless the donor presently exercised of a presently exercisable power of attorney has manifested an intent to the contrary, it is assumed that the donor intends that the donee's agent be permitted to exercise the power for the benefit of the donee. That's huge. For the benefit of the donee.
Abandoned property. Yeah, he's coming in as the donee to claim the abandoned property. Wow.
Well, no, he's the attorney in fact. He's coming in as the attorney in fact, but he can be exercised for the attorney in fact's benefit, as opposed to always for the benefit of the principal.
Wow.
Which is huge. So there's also in here you have a general. That's also a good phrase too. Presently exercisable general power of appointment with respect to what?
All right, hold on, Smoky Baby. I'm gonna mute everybody out because I want you to be able to flow, man. Things don't work right when we got people interrupted. Just flow. Here you go. Hold on, Smoky Baby. I'm gonna ask to unmute. All right, go ahead and unmute, brother.
Okay. So presently exercisable power of appointments. So there's general. There you go, general grant a general granting authority, general, there's only one. There's general grants of authority, and there's a specific general delegations of authority. So you have general delegation of authority and you specific delegations of authority. The other one's specific form of requirements, specific authority. So there's specific authorities. So under the Uniform Power of Attorney Act, you have general grants of authority, which are presumed unless you say no. And then you have specific grants of authority where you have to specifically state what you want them to do. Like for California, in order to have a power of attorney in California, you have to have a specific grant of authority related to real estate. Real estate has to be mentioned in the grant of authority, otherwise they won't report it in California. So if we go to page 136, I believe it is 126, 126. Agents, yeah, this is what they don't have in many states, the agent certificate of validity. So we have a power of attorney up here where they have an example of it. Grants of general authority. So the grants of general authority. The grant of authority provisions in the form are divided into sections. General grant of authority, which corresponds to the subjects, are defined in section 204 through 216, and the grant of specific authority, which is in 201. So they have the Uniform Act, and they have an example, termination of agent's authority. They have an example of what the power of attorney can look like, reliance on the power of attorney. So they have this example. Scroll up. I condensed it all into one page for mine. I don't like having multiple pages. Seems like they could slip something in. And Alabama power of attorney, important information. You have all this information here where they give you an example of what the power of attorney looks like. And my going through and reading all this to you, I mean, you can read it. I read it 3 or 4 times just because there's a lot of weird words in here that, reading it first time, it kind of washes over. And then I wait a day or two, then I read it again, then read the 3rd time, read it 4th time. And each time I read it, these weird words are no longer weird. And then they can start clicking together in the brain and how they all work together. This power of attorney becomes effective immediately. If you have questions, power of attorney, and you're granting, you should seek legal advice before signing this form. So it goes down here, designation of successor. It tells you why you should have a successor. It's good to have a successor in there. I don't name it in the power of attorney anymore. I put schedules into my power of attorney, which you'll see. So I can change the schedule without having to refile the power of attorney where someone specifically is named on the power of attorney document, naming someone specifically and that person disappears or you get in a fight or something like that. Or, wins the lottery and goes lives in Monaco or something like that. You'd have to redo it. So if you wish to grant specific authority over less than all the subjects enumerated in this section, you must initial each subject you want to include in the agent's authority. Real property over less than all the subjects, you would just check out the ones you want to grant them. And these are all mentioned inside this act here, what these all things mean. And then you have specific grants of authority. You have to initial next to each one of these or just list them and list all the specific grants of authority that you want to grant to your agent, donee, attorney, in fact. And for the all caps person here, my all caps person wanted to not restrict me at all, wanted to make everything perfectly open to me. There's no restrictions, thanks to my all caps person. It was very generous. And the reason I can do this power of attorney, because I've been signing for the all caps person since forever. And not to mention, I already have a power of attorney in the president. And so I can sign this document because I'm a man and I can sign documents, affidavits, and fictions can't. So because I'm already a signature for this all caps person, which is the all caps name, I can actually sign this document like I do an application or a lease agreement or anything else. I can sign this document. That's my authority to do so. It took me a while to say, why can I do this? It took me a while to figure that out. Why can I, how can, what gives me the permission to do this? And I finally woke up one morning, so fucking retard. I've been signing for the all caps name all the time. If I could do that for anything else, I could certainly grant a power of attorney from the all caps name to the last name proper case, comma, first middle name proper case, and I'll become the attorney in fact. So this is an example. I think it starts on page 116. I think it is 16, no, 15, 14. Yeah, page 113. And so I write up the power of attorney, which we'll see, and I go record the power of attorney. And on my power of attorney, on all my documents, I have a unique numbering system, which you'll see. It's a register mail number, a letter, 2 digits, and 3 digits. And then so once I have the power of attorney recorded in the county recorder's office, I then have to come back. If I appoint Derrick to some capacity, well, Derrick, no, I appointed you to be the agent for service of process for this particular thing. And Derrick goes, what? No, just because you write it down on a piece of paper, you can't make me work for you. We didn't even discuss it. I didn't even say I would want to do it. You can't make me do that. Just like if I were to write on the back of my 2000 Dodge Dakota truck that blew a head gasket and have to get that fixed. And said, well, Derrick, I'm gonna write your name on the back of this title. Now you're responsible for this broken down 2000 Dodge Dakota. Derrick, because you can write it down on the back of the title. Just because you write it on the back of the title doesn't make me responsible. I have to take the title, that title, down to the DMV and acknowledge and accept the transfer, and then I can be responsible for it. Same thing with the power of attorney. Just because I appoint someone power of attorney, and they mention it here in this Uniform Act, until the appointed agent acknowledges and accepts the appointment, they don't have all the powers of attorney available to them. So by perfecting the conveyance, all the powers of attorney open up to the appointed agent. So we go down here to page 126, starts right here. Agent certificate of validity, agent certification. A document substantially in the following format may be used by an agent to certify facts concerning the power of attorney. State and city, I so-and-so, an agent, name of agent, certify under penalty of perjury that the all caps person granted me authority as agent and or successor agent and a power of attorney dated such and such. I further certify that to my knowledge, the principal is alive. I put the principal is not deceased. Is what I put him. The principal is not deceased. I can't swear. I can't say he's alive. But I can say he's not deceased, right? And how do I know it's not deceased? I sent off on that SSA 711 form to get the decedent records from the Social Security Administration. And Ms. Zaborkin wrote back and says, our records do not show that the person is deceased. So I'm using her language from her letter. So I can't say the principal's alive. I can say the principal's not deceased because a third party wrote that to me from the Social Security Administration. The person's not deceased or has not revoked the power of attorney or my authority to act on the power of attorney. And the power of attorney and my authority to act on the power of attorney has not been terminated. If the power of attorney was drafted to become effective upon a happening event or contingency, the event is contingent here. I just say there is no contingency. And if I was named successor, it doesn't apply. And then they give you the other field. The other field is where all the good stuff goes. And then you have the signature acknowledgement of the appointed person, name, address. This document was acknowledged. The power of attorney has an acknowledgement, and this has an acknowledgement as well. And so in Florida, my nephew did his power of attorney and got it recorded. And then he went ahead and put together his certificate of validity, took it back into the same court over there in Daytona Beach, handed it to the clerk. And the clerk was looking at this. She says, what are you trying to do? He says, well, and all my powers of attorney don't open up to me until I accept the appointment. I need to acknowledge and accept the appointment to be the attorney in fact. She goes, I've never seen anything like this before. Hold on just a minute. Let me go check. And she walked back behind the wall to talk to the judge. All of a sudden, all the other women up there on the counter, they all got called back. And then all of a sudden, some lawyers came walking in. They walked back there, and they're having this little, do the hokey pokey dance. They're all back there talking, and all of a sudden, the lawyers come and walk out, and all of a sudden, the women come walking out, and the clerk comes back, and she was pointing pointing to stuff to the women before they went back to their stations. She came back to my nephew. She says, we certainly may and certainly will record this. This is one of the finest documents we've ever seen. They've never seen it before. Someone accepting the appointment, which is awesome. So now we're gonna show you what one looks like. Let me show you here. Let's go page down, page down, page down. Zoom. Oh yeah. DHS announces first department-wide policy on body-worn cameras. So anyone with a TWIC card kids are being trouble over there. My battery's dying. Acceptance of land, acceptance by the grantee constitutes part of the delivery of the deed. A good delivery may be effected, however, where the deed is given to a third party for the grantee, title company, or even where the grantor himself retains possession of the instrument. In these two latter instances, the question arises of how far an acceptance by the grantee, independent of such delivery, is essential to the passing of title. The English courts, though somewhat wavering, take the position that no acceptance is necessary. American courts, while ostensibly almost unanimous in asserting the necessity of acceptance, are really in conflict on the question. The apparent weight of the authority holds that where the deed is beneficial to the grantee, acceptance will be presumed in the absence of actual dissent. But a strong minority of decisions insist that even here, actual assent by the grantee is a prerequisite to the passing of title. How far the presumption doctrine has been carried is well illustrated in the recent Arkansas case, where a deed running to the wife, duly executed and delivered by the husband to a third party, was held to pass an immediate title, although it plainly appeared that the wife was ignorant of the existence of the deed until after the death of the grantor. The modern rule, there's a reason it was kept secret, because she could off him and or something like that and run away with it. The modern rule requiring grantees' assent to conveyance is said to have been established to obviate the practical difficulty of having title with its possible burdens forced upon an unwilling grantee, like the broken down 2000 Dodge Dakota, and is based as a matter of theory upon the conception that the transaction is contractual in nature. The fact that an insane person is capable of taking as grantee is, however, fatal to the theory of the doctrine. So crazy people need not apply. And on practical side, although the requirement of actual consent does not rescue the grantee from forced burdens, it also deprives them of benefits, since the rights of attaching creditors or third parties against the grantor accruing between the delivery and the assent must be prevail against the grantee. The presumption of the acceptance in the case of beneficial grants substantially relieves the latter situation of being burdened with some kind of debt obligations, but at the expense of grafting another odious fiction upon the law. One situation, however, even this doctrine fails to meet satisfactorily. Where land is conveyed upon trust, the deed cannot be regarded as beneficial to the grantee, and the basis of that presumption must fail, thus defeating the trust. The courts, however, have squarely met this situation by vesting title in the trustee without his assent, because a trust will not fail for the lack of a trustee, subject to the right of disclaimer. The same rule is applied in the case of title passing to a devisee. A disclaimer is either in either instance relating back the relation back doctrine so as to remove any burdens imposed. It is difficult to distinguish in principle between the conveyance upon trust and an absolute conveyance, so that the doctrine of title passing without the assent of the grantee, subject to disclaimer, would seem to be perfectly applicable to both cases, thus attaining practical benefit of the rule requiring assent without incurring objectionable features. So this is the Harvard Law Review. This is birth returns here. So I'm gonna go back over here. I'm gonna look at Leon real quick. Leon County. Acknowledge and acceptance of Leon County. Come on, click. There we go. Warranty deed. This is another acknowledgement acceptance. So this is deeding something away. Anytime there's a real estate, there's a warranty deed or grant deed in real estate transactions. But the problem is the grantee doesn't acknowledge and accept the grant. And so the real owner disappears. And now they create a fiction on the mortgagee to trust. And now the lawyers can step in to protect the real party in interest who has never appeared and claim their property. And then they can foreclose and put into a hedge fund and start renting it out for the presumed dead or disappeared person who is named on the grantee deed, the grantor deed. So it's a big nightmare. I mean, there's no acknowledgement and acceptance stuff. So this deed on the 31st of March between this corporation in Florida, a Florida corporation as grantor, and Gay Casares, a married woman. They created a fiction right there. Gay Casares, a married woman. They created a fiction. They screwed her right there. Whose post office is this post office box in Tallahassee as grantee. Wherever used herein, the terms grantor and grantee include all the parties to this instrument and their heirs and legal representative assigns of individuals and successors and assigns of corporations. Here's the grantor for in the consideration of the sum of $10 and other good and valuable consideration paid to the grantor by grantee, receipt whereof is hereby acknowledged by these presents, does grant, bargain, sell a lien, remise, release, convey, and confirm unto the grantee the following description of real property and rights and interest in real property located in situation in the county of Leon, state of Florida. Condominium unit number. So they gave her the unit number. That's good. Of the building of the Palms West, a condominium according to the declaration of condominium thereof, recorded in the official record books of 103 of page 1957, inclusive of the public records of Leon County, Florida, together with the undivided share in the common elements pertinent thereto. So I don't know. It seems a little sketchy. They don't talk about the volume inside or anything like that. It's kind of weird for a condominium. This conveyance is subject to the following: real estate taxes, drainages, the condominium bylaws, the covenants, storm drainage easements. You find a lot of these in your real estate too for non-condominiums. Facts that an accurate survey of personal inspection of the property would disclose taxes pending, acts done or suffered by the purchaser. Acts done or suffered by the purchaser. That's kind of weird, huh? What are they talking? What acts? What acts are they talking about? Consented to by the purchaser. Suffer means to consent. Riparian mineral rights, if any. Prior grants as oil mineral rights set forth in the trustee of internal improvement fund deed. Yada yada yada. Condominium Act, together with all the tenements and rudiments, appurtenances thereto belonging to or in any way appertaining to having to hold the same fee simple forever. Grantor fully warrants the title to this said real property and will defend the same against lawful claims of all persons whatsoever. And witness thereof, the grantor has caused these presents to be signed in his name is general partners this 31st of day in 1982. Signed by squiggle. They should have names under the squiggle, right? This Olivia and yada yada. There should be actually printed names down there. It's kind of shitty that way. And the development of corporation and the president. They hereby certify this is true by this notary. And That's a documentary stamp right here. Document stamp right there, the tax stamp. I've been trying to get one of those on my birth certificate for $10 to pay off the import tax. I haven't been able to do it yet. So she's been granted the property at this point with this the tax stamp and everything, where she paid the taxes on the $10. But down here, the taxes were paid on the grant. Then the problem is, it's not really hers until she acknowledges and accepts the grant from the grantee. The grantee, by acceptance and execution of this warranty deed, acknowledges that the conveyance is subject to every respect to the declaration of condominium and the exhibits attached thereto, including but not limited to, whether the same are attached to the declaration or referred to therein, the bylaws, the articles of corporation of the association. Grantee further acknowledges reading and examining, she has said she did it, said declaration referred above in this warranty deed, said exhibits, and further acknowledge that each and every provision of the foregoing is essential to the successful operation and management of the said condominium property in the best interest and for the benefit of all owners therein. Grantee and all owners of the parcels in the aforementioned described condominium covenant and agree to abide by in each and every provision of the said declaration of condominium and exhibit attached thereto. Grantee hereby affirms and approves of all the terms and provisions of this said declaration of condominium and exhibits attached here to. Witness, therefore, grantee is here to set his hand and seal on the 31st day of March 1982. Same squiggly people, and the purchaser. You notice they don't have the name up there like it says a married woman. It just says purchaser and her squiggle, and acknowledge and accept it. So this is what an acknowledgement acceptance looks like, which is done for real estate, but it's also done on the power of attorney. So we're gonna go back. Oh, bink, 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 bink. Okay, let's go back. BPP. Oh, come on. Let's go back here. Now we'll go back here. Beneficiaries control of the legal estate. I'm excited about that. That's W4 stuff, birth return. Okay. New POA. BBB. I mailed a register mail number. Oh, what happened? Oh, shit, pop up easy. Okay. Do you guys still see it? Derrick, do you?
Yep.
Okay. So that I mailed a register mail number to the all caps name, Sean Scott Haggard. So that's the register mail number. And on the back of the certificate, the registered mail certificate, I assigned the insurance policy that comes with every registered mail. I assigned it to the all caps name. So that insurance policy is now one of the first entries in the ledger. I actually have a ledger. I have a real ledger, a real paper ledger. In that ledger is that registered mail number and that $50,000 insurance policy. It's the first thing in the ledger. So this grant of authority does replace and supersede all previous powers of attorney. When you take this power of attorney, when you take this power of attorney and the agent certificate of validity, people send it to the credit reporting agencies, giving them instructions to remove all prejudicial information on the credit report, and they do, because they don't have the power of attorney. Same thing with the banks. The banks have an implied power of attorney. This revokes all powers of attorney.
Now, remember, that which is implied is removed by that which is expressed. So in other words, once you express in written form your authority, their implied presumption and assumption of having power of attorney is terminated. That which is expressed removes and terminates that which is implied. It's a maximum of law. Write it down and use it. And you can even use it in your power of attorney. Let it be known for and on the official record. That which is expressed removes that which is what is implied.
So you have donor principal, that all caps name, also known as that other all caps name, the franchise, and any other such combination representation of letter symbols, however styled, representing donor. At one point, I had put the birth certificate number in here and actually got it recorded. actually got it recorded down in Mobile, and done on the recorder down in Mobile, and got it authenticated, and then at the state level for Canada, and then we went up to DC to try to get it authenticated for the Canada's a dual part. Canada's not part of the Hague, so you have to get a federal authentication. And so we put it in for the federal authentication, and I was living up there then. Took the silver line down, walked in there, dropped it off, and then 3 days later went back to go pick it up, and the federally they had rejected the authentication because that the birth certificate number in the donor principal, they said that's wrong. I have to go find exactly what they said, but that's a defect. So they wouldn't do it with any type of numbers and symbols because I had numbers and symbols. That's why I had the birth certificate number in there because I thought the birth certificate number represented the name, but it doesn't. So it's not part of the name, that's an interesting anecdote. So just you can't put any weird numbers or anything. It has to be just the name, the name of the principal. Does hereby incorporate Alabama Uniform Power of Attorney Act and nominates and appoints donee agent. Some of these states have really funky, weird rules. So when you read the Uniform Power of Attorney Act, the uniform one, they have all these default provisions that apply, like it's automatically durable and things like that. And by incorporating the Uniform Act is one way to get around. You might get a little pushback because the clerks of whatever states that haven't enacted the Uniform Act, or even some of the states that have enacted the Uniform Act, they might get a pushback because they don't know what it actually says, so they don't know what to look for. So you might get some pushback because I just don't want a multi-page power of attorney because I don't like it. This is 2 pages because I want it on regular paper. So I incorporate the Uniform Power of Attorney Act in here to know as the basis, because I see some people just making things up. I don't know where they get the ideas for some of these powers of attorney, but they're kind of squirrely. And then appoint the I did it all caps last name, Sean Scott Haggerty, sui juris, also known as Sean Hayes, OKA, by Montgomery, Alabama, probate decree, baptismal certificate, memorandum, strong arm, true bailor, sedent and cestui trustant originalia. That's who I am. You realize the birth certificate's a bailment receipt. We bailed out the United States. And I'm also the sedent and the cestui. With authority to presently act as, remember the presently authority to act was inside that Uniform Power of Attorney Act. Like I highlighted it. Present authority to act as principal attorney in fact, settlor, executor, trustee, guardian, etc. ex rel below. So the all caps name is giving me all these capacities. It can give you as many capacities as the all caps name could occupy. Could grant those all to the donee. Then you have all these general grants, the grant of general authority, which they have listed in there. These are all the ones that are listed in there. And down here, the donor's grant of authority is with indefinite duration and shall not be affected by any subsequent. This is something I added. By any subsequent disability, incompetency, or legal incapacity of the donor or lapse of time. Legal incapacity, like you're going to get locked up, you know? You get locked up with that legal incapacity to seem to terminate the power of attorney. So I just made sure I expressly stated it that way. Legal incapacity. Grants a specific authority. Principal donor does grant agent donee and his assigned plenary, that means complete, and discretionary authority, ex rel general authority to act for donor in respect to the following subject matters and principal issue. With specific authority, donor grants donee authority to create, amend. These are all listed inside the Uniform Act. Change beneficial rights in any joint survivorship, including any survivor benefit, a retirement account plan, establish, manage, fund, a foundation. I added that to create a foundation. A foundation is an estate that has been incorporated. That's what a foundation is. When you incorporate an estate, it becomes a foundation. I have a document about that from Liechtenstein. Liechtenstein has the best overview about what foundations are and what they do and what they're for. In Liechtenstein, discretion to make full gifts exceeds the monetary section to 217, and then authority when it down here in these enumerated sections A, B, C. These are the ones I added. Authority to delegate another to exercise authority granted under this warrant of attorney, always with plenary and discretionary authority, ex-rel, real estate transactions, specific mention, chattel goods transactions, bond, share, and commodity transactions, banking transactions, business operating transactions, insurance transactions, claims and litigations, benefits from military service, records, reports, statements, tax matters, baggage effects and residue, and all other matters. This instrument terminates all prior guardianships over donor estate immediately, devising, assigning all rights, title, interest, and principal estate with general testamentary power of appointment, however conveyed, acquired, administered, vesting in toto to cedent, plenary potentiary donee. Plenary potentiary. Big words. Realize there's a decedent estate, right? There's a decedent estate because the estate has not been assigned. Once passed the way, we got it's like November 2 years ago, year before last. Let's talk about a decedent, and it's not dead yet. In Missouri, it says a decedent is one dying without a will. A decedent, it's not dead, it's dying without a will. So once there's a will in place, now it's deceased. Now, because the estate has been ceded, decedent. And so we're going to go back up here. Testamentary power of appointment. Testamentary. So now he's not dying intestate. Testamentary power of appointment, however conveyed, acquired, or administered, vesting in toto to the cedent, plenary. It means complete. Potentiary power, plenary potentiary donee, incapacities, personal representative, executor, trust protector, curator, conservator, guardian, settler, legatee, advisee, trustee, attorney in fact, ex-rel, the donor matters, whether approximately or directly related thereto, with a life estate vesting in trustee, this other person, his heirs and assigns, private trust board records, estates, you have N, private trust board records, estate assets, Schedule A, heirs and capacities, Schedule B, successor appointments, Schedule C. Because if I were to name, if any of these things were written down in this foundational document and it changed, you'd have to re-record it again. It's a pain in the ass. So I created some schedules. Now I can just go and change the schedules at will. Like if I have a successor, I can change my successors in and out and just give them notice of the meeting minutes. Private bond, the private trust board records. I can just take the meeting minutes out and send it off to somebody, and then I can terminate them at some point down the line without having to mucky muck with changing the foundational documents. I hope you appreciate that. Because you know how many of these I have recorded? Oh, I think 12 as I've grown since 2014 as I started doing this, as I started learning more and more. And then we have this unique one, that Derrick. This is Derrick's guru, divine inspiration. Donor does expressly grant donee plenary financial authority to make transaction requests executed as attorney in fact, seeking transfer of securities to or per attorney in fact donee instructions, and grants plenary authority over donor financial interest at large. We'll show you where that came from. Also, Florida also doesn't have this limitation section, which is part of the Uniform Act. Any agent other than the donee who has skip agents are not donor's ancestor, spouse, decedent, or heirs may not use estate property for skip agents' benefit or profit, nor any other person to whom the skip agents owe an obligation. They can't use, if you're not in the family, you can't use my stuff for paying off your debts for the skip agents, the ones that are arm's length, they're not part of the family, for obligation to support. Donee is without limitation to make gifts, and the following limitations apply. This is part of the Uniform Act. Any power or authority granted to my agent herein shall be limited to so as to prevent this power of attorney from causing and any agent to be taxed on donor income or from causing either donor assets or donor agent to be subject to the general power of appointment as defined in Title 26, 2038, 2514 of the Internal Revenue Code as amended, and doni as cedent sestui trustant sui juri holds general testamentary power of appointment rights per section 2041, which is not in the Uniform Act. Title 26, 2041 is a very weird section of the IRS code, which shall be construed to best serve doni interest. Because it's squirrely, I qualified it for the best interest of service of the doni. Doni's successor is not required to be bonded. That's also not in the Uniform Act, and not required to be bonded. Donor terminates all prior conservatorships, guardianships in favor of doni, and should any necessity for the court to appoint a receiver, conservator, or guardian in the event of doni incapacity, doni nominates doni's successors to act in receivership, guardianship, settler, conservatorship over doni estate and person. A copy of this instrument shall have the same force and effect as the original. That's also a key one. So there we go. So that's the power of attorney, my 2-pager. So I made it a testamentary will from the all caps person to me. So now it's dead. Now it's technically dead. Really, really dead, not merely dead. And then I went ahead and accepted the appointment. You know, anybody could walk in with a certificate of validity and say they're the appointee, right? Anybody could do that. And some could find that power of attorney, find it online, and go in there and start running around pretending to have the power. And so on my power of attorney, I should probably have mentioned it in there. You know, the certificate of validity shall have a photograph of the appointee. That might be a good thing to add to it. I'm not going to change it though. So I add everything that's in an ID card, everything that qualifies for an ID card. I have this little text box with a table inside of it with all this standard blah blah that's inside here, and it meets all the elements of an identification card. So when I go in and act as attorney, in fact, I bring in the certificate of validity and the power of attorney, and I bring it in and I use the book, page, and fee schedule, however you guys have it in your state. I use that fee number is the identification number, like the ID number, like a driver's license ID number. Is the ID number, and I use this credential that's recorded and gotten back out from the clerk's office. I use this document as identification because this is my credential. A creditor has credentials and a debtor has identification. Credentials are also authority. A debtor has no authority. So this, I use it as my credential, as my ID card, that they actually write down the information and use that fee number as my ID number in their notary manual. And then I have prepared, when I also go to the notary, I have prepared a notary journal entry copy request. And I have the notary copy my section where I record my documents in their notary journal. And the notary does a true copy certifications. As long as I'm there, I have the notary do it right then. And I get there was a court case where the judge threw out a notarization because the person came in, was some kind of remember the whole robo signers? They didn't have a journal entry proving there was an actual real notary doing the journal entry and not the robo signer. And so the judge threw out the case because there was no journal entry accompanying the notary, the notarized documents. So I always pull out journal entry copies, true and accurate copy of journal entries. At the same time, I'm already there because it's a pain in the ass to go back and get it again. And I also get anytime I record a document, I get 3 other certified copies of the document, and which is kind of expensive since I've done this 12 times, but it's a pain in the ass to go back and get certified copies. So this is the mug of some schmuck right here, and it's 2x2. It's a passport photo. Likeness of this Sean Scott, House of Haggerty, styled Sean Scott Haggerty, nationality Alabamian, domicile, I should say domicile of Odron, domicile and estate under the kingdom of God, residence residing in the state of grace, in the Son of God, political domicile, 10th Amendment, one of the people populating the American Republic. The American Republic was moved offshore in 1940. And then the Attorney General took over all the domestic duties that the Secretary of State used to have. Now the Secretary of State is nothing more than an arms dealer, murdering people all over the planet. We saw, he died. Sick woman. So the American Republic was moved offshore, and the only place there's any mention of the people as having a reserve is in the 10th Amendment. And Alabama is a reserve for Alabamians. And so my domicile is in the 10th Amendment, one of the people populating the American Republic. Because it says the people have the right to bear arms, right? The people are secure in their properties in effect. It says people, right? Derrick, would you agree with that? Or anybody? So if someone says the people have the right to bear arms, it says, well, are you one of the people? Have you taken up domicile in the 10th Amendment where the people are? If you're otherwise, you're still a person. And number two, you don't really have a name. You're an unknown belligerent inhabitant. They don't know you exist because you haven't done the birth return, because the infant was found, the child was purchased on the birth certificate, and the mom went home with the baby, never to be heard from again, because the baby's not even mentioned. And they're all caps names, and they're all fictions. And the state cannot, just like Mrs. Zaporkin said, our records do not show the person's deceased. The state cannot create anything on behalf of the living. The state doesn't have authority to mess around with the living because they're all dead fictions. So the mom and dad have to do a birth return and actually document the baby. But they don't do that documentation of the baby, and that's why the estates end probate, because the baby's lost at sea. Okay. So they have the 10th Amendment. If you haven't made a declaration of political domicile in the 10th Amendment as one of the people populating the American Republic, and you can find the American Republic in Google, just to show you, 22 USC 611. Enter definitions, Control F, American Republic. The term American Republic includes any of the states which were signatory to the final act of the second meeting of the Ministers of Foreign Affairs of the American Republic's Havana, Cuba, 1930. So that's the American Republic. It's not what you think it is. And there's I should get this in there. I'm going to escape out of here. Fake kings, false kings of America, and where they hid it. Justice Lotus, false kings of America, and where they hid it. This is, Justice Lotus. She, I guess she's alive. She got shot up and everything. They were actually trying to assassinate her because she had captured captured the United States. And one of the things she filed, she talks about the fake kings of America and where they hid it, talking about that Title 22, 611. And I didn't know about this video until I had started doing my own research for becoming a foreign agent for the IMF, which I'm recognized as a foreign agent for the International Monetary Fund by the Department of Justice, which is fun. And so it's a really good video. It's on BitChute. Because, or to the people, popular sovereignty and the power to choose government. This is what this is the. I'll put this up. I read this link 3 or 4 times too, because they talked about all the different ways. And when we kept doing this and conquering that, and bringing in immigrants and conquering places that already had people, and what was their disposition, were they a national, were they a full citizen, all these nuances of 6 different types of citizen, all with different rights, title, interests, duties, obligations, privileges, and immunities, different depending on the status. But this little section right here is poetry. It says, there is a set of powers relating to the federal government, but not delegated to it, that states cannot have reserved because they lack prior ownership. Those powers must belong to the people. In addition to the 2 sovereign governments is the non-government sovereign. That is the original source of all governmental powers that keeps government sovereigns legitimate by connecting them directly to the will and consent of the people. It is the people who retain ultimate supreme sovereign authority over both state and federal governments. And indeed, the people must have a separate voice, be a separate sovereign, in order to truly give legitimacy to either government, state or federal. And the people who could not disagree with, and if necessary, withdraw the consent from the government, from their government, is a captured people, whose government is certainly not a democracy, and it is not far-fetched to call it a kind of tyranny. In the 10th Amendment is skepticism of expanding governmental power, both federal and state. That's one of the most beautiful, beautiful paragraphs I've ever read. So, setting ourselves up in the 10th Amendment, also to be known. There's a way to be known because the government doesn't know who we are. They don't know we exist. They don't know if the baby's alive. And even if the baby is alive, how do they know if I'm the baby that was the baby that was the baby then? Smoking baby. And so now we have to create the record because the government cannot document humans. David did that and he got his ass kicked in the Bible. David, anyone that shacked up with his chief general's granddaughter and knocked her up because David wasn't going to war, but her husband was going to the war, and the husband came back and David had her husband killed. And then David was so sad about it afterwards. I don't like David in the Bible. The King David enumerated the people and he got his ass kicked. So we'll put this in there too, or to the people. And I read these things enough where I like Derrick does with Title 15 and all that, where it's just second nature. Because if they want to challenge me, I'm going to be able to speak from the heart and not the head. Like Kevin, my classmate at the academy, from Kevin, rights, title, interest, duty, and obligations. The issuer owes to the owner of the certificate, issued the certificate. And he had his eyes closed. And he was moving his lips, but he wasn't talking out of the heart. When he talked out of the heart and decided before that judge, the judge got cattle prodded on his pucker and about leaped out. He did. He actually lurched up in the chair. It was a marvelous thing to see. Do you deny having a social security number? The social security number is tied to the estate with his hands moving, showing conviction. Your hands move if you're talking. Like the Italians, they're all talking out of their heart. Their hands are moving. So I'll drop this in the chat too. Read it to know it. Read it to know it. Okay. So now that we want to be one of the people, how do we even become known alive? Of course, we have they appointed the last name, comma, first middle. I capitalized the last name because a capital on the last name came that way on an SF61 when I did the OPM SF61. On my SF61. Come on. Page down. There's a lot of things in here. I can see it from here. Copy, TSA, FOIA, Consular Affairs. Where is it, Kevin? Where is it? Clayton Act forms. Activity. Where's OPM? I'll show you where it says I don't have a SF61 on file. Maybe it's another one, S61. Try this one. Nope. Doctrine of merger. It must be in here. It's interesting. They mangle the names just like they did with a married woman when they screwed that woman out of her title on that Leon County, Form 56, DOJ request for U.S. Attorney Title 27. IRS loses challenge to prove tax liability. Public notice, Clayton Act form, DOJ taxable event, fillable, TSA acknowledgement, name change, DOJ, 0520, OPM. Type in OPM, Office of Personal OPM. Appointment affidavit bootleg. I'm sorry, guys. I just want to kind of obsessed now trying to find it. Standard form. DD 214. Let's go here. Here we go. So they have this Sean S. Haggerty person, whatever that is, veteran's name, Haggerty, Sean Scott. Isn't that weird? There's one permutation, another permutation. And then we come down here. SF61 is not a matter of record. Why is that important for you to get? Or either from the DFIS or DFAS or the Office of Personnel Management? Because if I've never been appointed into public office, then I've never engaged in a trade or business. The only way to engage in a trade or business is to hold public office, because trade or business is defined one holding trade or business, one engaged is one holding public office. So the only way to have taxable income is to be engaged in a trade or business in the United States. So for me to have a taxable income, I would have to engage in a trade or business in the United States holding public office. And the SF61 is an appointment to public office. So by having this record here, it proves that I've never held public office, therefore never engaged in a trade or business, and therefore I've never had a taxable income, which means give me back all my credits. So this is important. But it's just odd that we came out with Sean S. Haggerty, and all caps Haggerty, all caps Sean S. Haggerty, and then Haggerty Sean Scott, Haggerty proper case Sean Scott. And then you come down here. This is the oath of office under supposedly 3331 oath, supposedly the 33. See right here, authority 5 USC 3331, executive order 4397. You think they would have better scanners? Air Force being in seeing things from outer space. Regular service. Look who took the oath. Look who took the oath. Should we get down? This I, all caps person name, social security number, have the social security card was appointed to the Air Force, not me. Appointed a second lieutenant. So solemnly swear affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I make this obligation freely without any mental reservation or purpose of evasion, that I will well and faithfully discharge the duties of the office upon which I'm about to enter. Here's the defect. So help me God is in all caps letters. That's not part of the oath, and it doesn't conform with statute. If you look in the statute, it has proper case, so help me God. So this is a bogus oath appointing the social security person to go in the military, and then the human being steps in and commits war crimes because of the oath. Everyone in the military are mercenaries committing war crimes, all of them. Everyone in the Air Force. So we have a Sean S. Haggerty person, and we have a Haggerty all caps comma Sean Scott person. Then we have this Sean Scott Haggerty all caps person tied to a number, and then they come down here, type or print, name, grade, and organization. Then we have this Sean S. period Haggerty 2LT comma USAF. Wait a minute, that's a brand new fiction name. Remember, a married woman? That's a fictitious business name. That's a fictitious business name. And then down here, of course, look up here. I have Sean S. period Haggerty 2LT USAF, but look at my dad, James A. period Haggerty LT. It's all proper case. Isn't that weird? It's completely different. Anyway, 28th of May, 1986. So I'm pointing that out of why I put the Haggerty comma Sean Scott, because I'm also taking over that social security number as well. I just wanted to link them together for the all caps. The all caps person is tying in this Haggerty Sean Scott for the SF61 person and tying them in together to be the attorney in fact. That was my intention. That was my thinking. I just wanted to add them in there. These are my FOIAs showing I never had tax. So now we have the power of attorney done. We have the certificate of validity done. And we looked at the certificate of validity, right? Yeah, we did. Let me go back. If you notice in my certificate of validity, I linked the power of attorney to the certificate of validity. Go page down, 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 page down. Successor. You see right here, this number right here? On my so we went through this, the identification side with a picture of my mug, and then we were down there playing around with Justice Lotus about the domicile in the 10th Amendment to be one of the people. And then I use hands and stone, how many hands tall I am, and how many stone I am. And the way to do that is you go to Google, you type in 180 lbs equals question mark stone. It does a conversion for you. You do the same thing. How about cubits? Let me see. 69 inches equals question mark cubits. Let's see what that is. Oh, they don't have cubits? Oh, cubits to feet. Cubits. Oh, they don't do that. Anyways, hands. Hands. Why does it? It's where it's not doing it. 69 inches in hands. Let's do 5'9". 5'9" inches. What's going on, Google? 9 inches. That's weird. Let's do this with it. There we go. Oh, these Google's an asshole. Let's put cubits in there again. Cubits. Nope. Cu. Feet inches. So anyway, I use Google to do the transformation. Sorry, I got stuck down a rabbit hole because it pissed me off. The reason I did the reason I use hands and stone is because we've been on the metric system since the 1890s when Congress brought in the metric system, and we're also on the American system, the whatever it's called, the normal inches and feet and miles. And so Congress has already legislated those units of measure. And if I were to use those, you know, how many feet and how many pounds, I would be taking a benefit of using Congress's weights and measures. They could be construed as waiving sovereign immunity by taking a benefit. And I don't want to do that. So I use hands and stone, ancient measures. Hazel black, I don't abbreviate. Conception day is around that time. Date of birth date is that date. This is my NAC number. There's a NAC tag. It converts latitude and longitude into a string of numbers. And you can actually use the mail system to actually get mail to this NAC code. And every ID needs an expiration date. I had a credential before and it didn't have an expiration date. And the note to go call National Notary Association. The National Notary Association, who bonds her, says, oh, there's no expiration date, so it can't be used as an ID. So I added an expiration date, 120 years from the date of birth, because that's when you're really, really dead. 120 years. They issue a death certificate to anyone lost at sea and they haven't been seen in 120 years. Then they're really, really dead, just like the Wizard of Oz. Really, really dead, not merely dead. So, and then I have my, do you guys know about, I can't even ask you guys questions. This is the rural route address. There's two different mail systems in the United States. LOC, 3-cent mail. There's two different mail systems in the United States. 1863. Let's go down here. At the first time,
what he's about to show you guys is extraordinarily important, and I hope that you guys understand what he's about to explain to you and show you. And so, really pay attention to this.
So it's I'm going to the middle of this. We can page back earlier. So this is first class, second class, third class mail. you hear about this thing. First class mail, so where's second class mail? You want to play with the clerks at the post office? Ask about second class mail. It plays with their head. If there's first class mail, there must be second class mail. Otherwise, it would just be mail. They really get freaked out. Third class embraces all other matter which is hereinafter by declared mailable, embracing all pamphlets, like publications, books, manuscripts, proofs. That's like a third class mail is like book rate. Book rate's really cheap. It says, section 21, and be it further enacted that the maximum standard weight for a single rate of letter postage is 1/2 ounce avoirdupois. That's of weight and some French weight, probably measured in cheese. And number 22, the rate of postage on all domestic letters transmitted in the mails of the United States and not exceeding 1/2 ounce in weight shall be uniform at 3 cents. And for each 1/2 ounce or fraction thereof of additional weight, there shall be charged an additional rate of 3 cents to be, in all cases, prepaid by the postage stamps plainly affixed to the letter. Transmitted in the mails of the United States. They made it qualify it. They qualify it. Anytime they qualify something, it always, my ears perk up. Let's look at 23. That the rate of postage on all letters not transmitted through the mails of the United States, but delivered through the post office or its carriers, commonly described as local or drop letters not exceeding 1/2 ounce in weight, shall be uniform at 2 cents. An additional rate for each 1/2 ounce of additional weight to be, in all cases, prepaid by postage stamps affixed to the envelope of such letter, but no extra postage or carrier's fee shall hereinafter be charged or collected upon letters delivered by carriers, nor upon letters collected by them for mailing or delivery. No carrier fees. Then we go down to the very bottom, letter postage. I'll put the link in there. It's fun to read this stuff. Down here, if anyone in the military, and be it further enacted that the Postmaster General is authorized to provide by uniform regulation for transmitting unpaid and duly certified letters of soldiers, sailors, Marines in the service of the United States to destination, and all other letters which from accident or neglect appear to have been deposited for mailing without prepayment of any postage, where in the latter case the writer is not known or cannot be promptly advised of his default, but in all cases letters not prepaid, blah blah blah. So military has free mail, and if we use the postal route, it's only 2 cents, which I still use 2 cents. But through mails of the United States, that's why it was 65 cents, 68 cents for first class mail now, whatever it is. So the question is, where do we find this postal carrier? Nonsense. Let's go to UPS.com, USPS.com. Let's go to QuickBooks. Up here, the quick tools. Let's look up the zip codes. So I'm going to go in here, and I'm going to write in, what should I put in here? 23422. I can't remember my old address. I just have to use mine. I don't want any mail in the mail. Some people write me mail in the mail, real mail, as if they know me. And it's kind of odd. Connemara Drive. Connemara, M-A-R. Connemara is a pony. Santana Valley, Arizona. No sense using the zip code. So there's the 9-digit EIN number for this Federal Reserve overlay. Has a 9-digit EIN number. This 5+4. There's a little Federal Reserve zone that encompasses, and it's actually a tax ID number. This 9-digit number. See right here, carrier route. This little tricky little thing here, it's very nondescript, but you click it and it shows you the carrier route number for the carrier mail that is outside the mails of the United States. If anyone's worked in an office where you have a cube number and a building number or something like that, you can take inter-office mail in that little envelope with the holes in it and that little string that twirls round and round. You can put something inside that manila envelope with holes in it, and you can write down the name and the cube number and another building and put it and drop it off in the inter-office mail, and that little envelope, inter-office mail with no postage, will go and get delivered by some clerk who goes around, picks up mail, and redistributes all this inter-office mail. Well, the zip code and AZ are similar to inter-office mail, where it's known to the United States. But if I were to do something like that inside the office with a zip code or something, they go, what are you talking about? We don't have cubes designated by that. So these little zip codes is inter-office mail under the United States Corporation, just like I had inter-office mail under Princess Cruise Lines. I could do inter-office mail from building to building without having to go walk and be away from my desk and get in trouble because I'm not at my desk, which they like to bitch about. So that's the carrier number right here. And that's the rule route, rule mail. Here's another interesting thing. We'll redo the address again real quick. We'll do Connemara Drive East. Let's see what happens here. 1959. Tan Valley, Arizona. Let's see what Arizona. Okay, click enter. Find. Look at this. Odd range. So I'm in the odd range. But then these other houses over here, they even have a different 3-digit designator. You know, just across the street has a different 9-digit number. It's just interesting playing with putting the mail in all these different ways. What are you doing, sweetheart? What are you doing? Want to get some pettings? These cats. Having fun with the post office. And one other thing you want to eventually go down here and do, you want to go down here to the bottom, and you want to go down here to the business gateway, and you can sign in, and you can get a customer relation ID and a mail ID, a CRID and a MID. And so you have a contract with the postal service. You're not just some random person stuffing in there. And I use the CRID and MID when I make complaints to the Postal Inspector General for mail fraud. So I have a contract with them. So because I'm registered inside their system, I can hold their feet to the fire. You get someone taken to the postal court in Alexandria for falsifying the green card when they don't write their full legal name. And the full legal name, which is we saw last night, is first name, middle name, last name. When they put the name on that little green card and they don't fill it out completely, they have falsified a government record. Because I want to know who that person was that touched that envelope and signed for that green card. I need to call them in to testify. And if they falsify the name, now to do an obstruction of justice, I need their full legal name. So I can hold the feet to the fire for the Postal Inspector General, Postal Police to go out there, tap on the door, and get that person's full legal name when they falsify a government document, the return receipt. So that's fun to do. At least I think it's fun. Boom, boom. Carnella, American Republic. What's this here? This is Power of Attorney Act. Page down, page up, page up. What's this in here? UPOL, Uniform Power of Attorney Act. This is how you get. This is how you can. This is like an SS4 without the SS4, and it's really simple to do. Because you have one for a trust, 05 is trust, 04 is estate, different from a bankruptcy estate. And they have all these other forms in there, but fun to look at those forms anyway. So you can do one of those to get an estate, maritime law, indemnification and contribution. That's why we have insurance, liability among joint tortfeasors. That's my VPN. Here's the full legal name, full compliance, full legal name right here. No nicknames. What's the legal name for Social Security Administration purposes? Oh, we'll get to that. We'll get to that. Here's the Uniform Power of Attorney Act. So when we go back to the Uniform Power of Attorney Act, that's where I was headed. I want to look at something real quick and show you how I tie right here at 12/22/23 at 13:44 hours, the private document locator number, this number right here, this DLN document locator number, this is the same number that's on my power of attorney. And this one up here has number 2. So in order to link, because if someone were to bring in this certificate of validity saying I'm the attorney in fact, and it's just some piece of paper that says I'm the attorney in fact and has some blah blah in there and it's notarized, and go, well, where's the original power of attorney? You didn't bring that in just because you bring a piece of paper, and I want to see the original. I want to see what authority you're granted in the general and specific grants of authority and what limitations you have. I asked that to the attorneys too. Where's your warrant of attorney showing the scope and authority and your limitations, and who the original party is, on whose behalf you're acting, and who carries the primary active degree of fault. That freaks them out. You ask the lawyers for that too. And so down here it says principal is yet extant. That means not dead. Principal has not terminated the grant of authority. Principal limits donee authority, preventing agent donee from tax liability on donor income or causing donee assets being subject to a general power of appointment under 2041, 2038, and 2514. Donee is not required to be bonded, which none of these lawyers and judges are bonded out there. They're not bonded. They don't have an appointment. They haven't notified the Treasury, the Secretary in Puerto Rico under 6903 that they're administering the estate, which is the reason they need to be bonded in case they damage the estate. And they're just engaged in money laundering, securities fraud, and tax evasion by not having a 6903 certificate, sending a notice and getting a certificate from the Treasury in Puerto Rico, not having a bond on file under 2032A11. Successor nominee is named on the principal letter patent. It's in that schedule. Donee does acknowledge and accept donor immediate testamentary appointment to presently act with plenary, potentiary, executor, trust, protector, settler, legatee, trustee, ex-rel, estate, all attorney in fact, authority in toto as of 12/12/2023 at 13:44 hours. Any person may rely upon the validity of the certificate and copies thereof unless such person has firsthand knowledge of said grant of authority remains invalid or terminated. Copies carry the same force effect as the original. This little caveat I put in here: the witnessing attorney seal does not constitute an adhesion or election by signatories electing residents in this state or an election electing collective entity doctrine benefits. Rather, the purpose of the notary seal is for verification of identification purposes only and not for establishing statutory residence. Because taking this benefit from this notary could create an adhesion. Oh, you came in here and took a benefit. Well, guess what? You're now part of the pack. You're one of the general partners carrying joint liability with all the rest of us down here. So that's the purpose of that caveat. So now we're coming back over here to the right-hand side, because we read down there to show how the power of attorney is linked to the certificate of validity and all the qualifications and reservations I make. Down here in the communication portal, a delivery address is a military address. 1959 East Connemara Drive is a delivery address. The military delivers ordnance. Stuff that comes in the mail is violence. There's a lot of violence that comes to that mailbox. And the Postmaster General is in charge of that violence that comes to the mailbox. Postmaster General grants Navy ships to go sail around and bomb the Houthis. You know, the Navy needs permission from the Postmaster General to go sail around the nation where they go in the globe. I suppose we needed it too in the Air Force to go fly around in the skies. We need permission from the Postmaster. So instead of, I call it a communication portal. So there's a delivery address, and then there's a mail location, the mail location, and the rule route has a local drop letter location. That's care of R029. That was my carrier route. That's the carrier route number, R029 Connemara Drive East. I invert it. When you invert it, if you get the inverted address onto your driver's license, they can't write you a speeding ticket because you're outside the United States. They can't. It won't stick. It just won't stick. 19 East Connemara Drive East, all spelled out, no abbreviations, because abbreviations a benefit. Santan Valley, Arizona, non-domestic, zip exempt, the United States of America. And right here's LS means locus sigilli. That's a Roman term, the seal of the person signing. Agent's authority, and I put my right thumbprint. In Arizona, you can use your right thumbprint as a signature. It's in the notary manual. A right thumbprint can be used in lieu of a signature. So I put a right thumbprint in there with my squiggle, with a mail location, with my biometrics, with a picture, and recorded. Now all of the elements in there for identification card, only it's a credential, I can use instead of using a driver's license. Why would I go in there to claim to be the attorney of fact and use the driver's license? It doesn't make sense. The driver's license only authorizes the security person to engage in commercial use of the public roads or private game. So I use this as my credential for the power of attorney, and they're linked. So that's a lot of information. Did I miss anything there?
No, I don't think at all. We made a conscious decision to make sure that every time that we hold a class in the future, that they walk away with some form of instant gratification. And so I don't know which credential you'd like to walk them through, or like the TWIC card, a slight demonstration of how to walk through point by point by point, or the Federal Creditors Registry is in my opinion, especially with what I taught last night in the banking class, I think that would be most beneficial for everybody that participated. I don't know if somebody wants to walk through it and fill it out so everybody can see it, and then stop their screen share when they get to the point where they might be entering in some information that they don't want shared publicly because other people are recording this. I'm sure it'll be disseminated amongst people or whatever. But if somebody wants to volunteer to walk through that, we can literally walk you through it step by step by step. And when you're done and you have it submitted, you'll have a reference number, which is a receipt, which is proof that you are registered in the National Federal Creditors Registry. And now when you go into a court and there's an alleged creditor proclaiming to be a creditor, you can pull out your certificate and say, I'm registered on the National Creditors Registry. Where's your evidence of you being registered? Federal National Creditors Registry, because you're alleging that you're a creditor, and that's all fine and dandy, but here's my evidence. Where's yours? So I like to pretend that we're in what is it? Missouri's the show me state. When I go into court, I'm always like, let's just hypothetically pretend we're in Missouri. And they're like, excuse me, let's pretend we're in the show me state. I'll show you mine, you show me yours, and I'll go first. And they know immediately, because I'm being cocky, that I already have mine. And they want to avoid that like the plague. And I think it's funny. And I say, let it be known on the record, for and on the official record. Their failure to respond timely is an admission by omission that they are not and do not have evidence that they are in fact a creditor in the situation. And it just changes things around, because how can I be a debtor if they themselves are not a creditor? How could they extend credit if they're not the creditor? It's very important. Melissa says that she is willing to volunteer in screen sharing and as you walk her through that smoking baby.
So everyone, I put the link in the room, and see right here, this little nondescript, it should be bold and blue or something more than just what it is. There's a link right here. When you click that, this will take you over to here, and you click again. They love wait. Where's that? Electronic filing requirements. Is it working there? Where is it? No cost. Legal help. No. Where is it? There we go. There we go. I'll just put this directly in there. You can have fun navigate. The reason I like to walk through the navigation, so you can see how they have their website set up and the way they're thinking about it, as retarded as it is. So making it easier to navigate as you go march around. Later on, you march around all these tabs. So she can pull this up, and I'm going to show you one more thing about the National Creditors Registry. Let me go back. I'll just show you ahead of time. Petition for name change. Petition. Need to find it. Let me find it again. National Creditor Registry. National Creditor Registry has attachments. Okay, stocks. So, when you go through the process, when you get done, you're going to have a BNC. Let me type in BNC. 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 There we go. I don't want to show BNC. 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 When you type in all your blah blah, you're gonna print this PDF thing here, and you take it in. See, it has this little bankruptcy and notice center number. You get this number here, and you have to go down there and you have to get it signed, and then you have to email it to them, email it back to them. So this is once you have all this done, then you email it back to them, and then they'll set up your account, and then you'll get an account number. And what's interesting for the account number, just to do one more thing, let's do SS5FS. Let me divide SS5FS. Go here. Let's see, where's my SS5? SS5, SS5, right here. You see this right here? Other names used. See, National Creditor Registration Service numbers. This is mine, because in this National Creditor Registry number, you can list all the names you've ever been used, all the bastardized, mangalized, retarded names like the capital H Haggerty, comma, S period, S, no period, no middle name, no middle initial. Sean Scott pushed together Haggerty. That's in my credit report. Sean Scott as a compound name, no space. All the different mangled names you can add to the National Creditors Registry. And then for the Social Security Administration, I just, for the other names used, I pointed to the BNC. And they were perfectly fine with that. So I'll stop sharing.
The importance of doing that is later on when we're reclaiming the securities, it makes it easier for them to track down all the names that have ever been utilized with that social security number in order to draw credit or issue securities, whether knowingly or unknowingly or unbeknownst to you, have transpired. Because remember, these agents and agency have been hypothecating your credit into existence for a long time. And for the first 18 years of your life, they were the alleged agents and agency were the trustees responsible for making sound investments for the benefit of the estate. It was never for the benefit of the beneficiary. I want to be very clear on that. Everything they're doing is for the benefit of the estate. The beneficiary is nothing more than a teenager whining for a bottle, essentially. So when people run around going, I'm the beneficiary, and start barking orders, I go, good, sit down, shut the fuck up. I'm the trustee. And my fiduciary duty and alliance and allegiance is not to cater to the beneficiary as though I'm your servant. It is to protect the interest of the estate for and on behalf of the estate. It has absolutely fuck all to do with the beneficiary. So people that run around going, I'm the beneficiary, you're going to do this, you're going to do that. That's the wrong approach. Wrong approach. Okay. I'm the grantor. I operate in a certain capacity when I want something done. I'm the grantor. I issued this application. It has been improperly applied or misapplied, and therefore I'm recalling all the rights, titles, and interests that rightfully belong to the estate. I'm going to need a full account. I'm going to need all that information back. The accounts you open, whatever. There are times it's beneficial to be the trustee or the attorney in fact. I'm the attorney in fact on behalf of the principal coming forward to protect the interest of the estate. So I'm going to need full accounting. And here's my credentials. And here's the power of attorney. And here's the acknowledgement and acceptance. All right. And so what we're trying to help you guys ascend to the mind of being able to do is handle your own affairs and create the separation between you and that fucking name, because I see so many people struggle to let go of that fucking thing. Let it go. Let it go. It is an anchor. It is a millstone dragging you to the bottom of the fucking ocean for idolatry. It's a false idol. Let go of that driver's license. It's a false fucking idol. It's a decapitated false God. It's a false image. Remember, you are made in the likeness of the Heavenly Father. Okay, let us make man in our image and our likeness. So when you start creating driver's license with your image on it, That's a false god and a false idol.
And, and Derek, if you remember, God called him Adam and then told Adam to name the animals. So if there's a name, it means animal. And an interesting thing, the word drugs, when they talk about drugs, drugs are only for animals. So this whole vaccine drugs, that's for animals. So I'm called, I have a calling.
Yep, that's found in Title 7. Would you go through and run through the 12 names of the Bible that talks about man suffering? It's so good and it's so brilliant,
you mean Genesis 5,
yeah, it's Adam, Noah,
the godly names of the godly line of Adam.
Yeah, and what it actually says, eternally man shall suffer or something along those lines. I can't remember verbatim.
It's in Genesis 5, you have the 10 generations of Adam, the godly line. In Genesis 4, you have Cain's lineage. And Cain's lineage has its own, all the names, you put the names in order. So if we go through Genesis 5, it says Adam lived however many years and had a son named Seth. Cain and Abel were discarded. Cain and Abel were not Abel. Yeah, Cain and Abel. So Cain killed Abel. How long did it take for murder to happen in the Garden of Eden? As soon as Cain was able. That's how fast murder happened. And there's a whole thing about, Eve had intercourse with the serpent, and her womb was polluted for 7 years. For 7 years, the womb is polluted after that, according to the there's a video about it. And then they had Cain. And Cain first was Cain, that's the serpent seed. And then you had Abel, and Abel was murdered. And then Cain's lineage is a completely different, is a serpent seed, which is a synagogue of Satan people. And then the first kid of God, the godly line, was Seth. And so you have Adam, and then Adam begets Seth. And so you have Adam, Seth, Enosh, Cainan, Mahael, Jared, Methuselah, Lamech, Noah. Let me say, he had Adam, Seth, Enosh, Cainan, Mahael, the first one. Then you have Jared, Methuselah, Lamech. Oh, I'm missing one. I can't remember him. Adam, Seth, Enosh, Cainan, Mahael. And then you had Jared, Enoch, Methuselah, Lamech, Noah. That's 10. Adam means man. Seth means appointed. Cainan means mortal or to die. Adam, Seth, Enosh. Adam, Seth, Cainan. Oh, I can't do it. So it means man appointed unto death sorrowful. From the presence of El. El means God. Mahael, the first Hawaiian. From the presence of God, one comes down. Jared, dedicated. Enoch. Enoch was dedicated and was raptured at 360 years. The book of Enoch is awesome. From the presence of God, one comes down dedicated, and dying he shall send Methuselah. Methuselah was a living prophet. As soon as Methuselah died, the flood came. So dying he shall send to the poor and lowly, Lamech, poor and lowly, rest and comfort. So you got man appointed unto death sorrowful. From the presence of God, one comes down dedicated, and dying he shall send to the poor and lowly, rest and comfort. The interesting thing is, Adam died. Adam saw all his generations up until Noah. He never saw Noah. He died before Noah was born. So Adam, in his whole life, never saw rest and comfort. Or you could say Adam also means man. And it means mud, it means red. So we can also say man never sees rest and comfort until we're dead. And so Adam lived to be.
Yeah, man is not meant to be comfortable on this earth. That's not what our purpose on this earth is for.
We have a comfort. We have a comfort. We have a comforter, or the Holy Spirit is our comforter. And then so Adam lived to be 969 years, and it was kind of a mercy killing for Adam to die before he saw Noah, because when the flood came, imagine sitting there and watching all your generations being wiped out, all your children, and your children, even your bastardized children, watching them all be murdered off. What a horror show that would be. So it's kind of a mercy killing that Adam didn't have, as Adam lived his 939 years versus Methuselah 969 years. Adam's sitting there watching the complete debauchery of all his generations. It's only this one lineage that was the godly line, and it's a so it was a mercy killing for Adam. I just wondered. I'm sitting there wondering. You never heard from Eve again after they got kicked out of the garden. God said, "Through woman's seed will come her salvation. Come your salvation, Adam." And Adam changed her name from woman to Chava, giver of life. So Adam believed, and then Eve, when she conceived, she says, "Oh, look, it's a man child." She also believed that salvation would come. So Adam and Eve made it to heaven. But I just wondered, as those 969 years of Adam, because on the day you sin, you shall surely die. Well, Adam lived 969 years. Well, a day is as 1,000 years, and 1,000 years is a day in the kingdom of heaven. So Adam in his day on earth lived 969 years. So it says if I'm in the state of Arizona for more than 180 days, I'm presumed to be a resident. I says, well, I can't be here for 180 days because I'm only here for a day. I'm only sojourning here for a day. I can't be here for 180 days. There's no way I could be a resident because a day is like 1,000 years, 1,000 years like a day. But as Adam was marching along those 969 years, having how many more kids, banging them out for all that time. I wonder how long before he finally realized that it didn't really matter that the man child that was promised wasn't coming, before he just realized, oh my God, I am fucked. I chose a piece of ass over God, and I'm screwed. I wonder how old do you think he was when he finally realized it doesn't matter how long it's going to be, I'm screwed. The man child that was promised for my salvation is not coming. How old do you think he was?
Definitely uncertain of that. Melissa, do you have that pulled up? And if so, are you able to share your screen? If you're still willing to be a willing participant, so we can walk you through this, so everybody can see it, and they can follow along or do it on their own on a separate device.
You know how old I think he was? 666 years. 666 years old.
Oh wow. Okay, Melissa's going to share the screen. She doesn't have the ability to communicate with you, but we'll see how well she follows directions. So this will probably be really good. And Melissa, when you get to a point where you have to enter in any private intellectual information that you don't wish to share with anybody, just be advised this is being recorded by a number of people and more than likely will be disseminated to people. So in the interest of privacy and protecting your information, if you at any point it's asking for certain information,
you can put fakes. You can put
stop share screen.
But when it comes back on, you could just put bogus information in there, just to how would like 123 Main Street, and then just to show how it's filled out, and you can go back in and fill in the real data, and you can and then you can hit submit, and when you hit submit, then you're gonna download that PDF file.
All right, let's get started here. Smoker Baby, go ahead.
So accept their National Creditor Registration Service NCRS link. See the NCRS link? Yeah, click. Woohoo! Sign up for service today. So you probably want your email address. Receive notices on behalf of my email address. That's good. Add or update.
Now pay attention because you guys can change this at any time. This isn't fixed in time. Once it's done, you can always go back and amend. Let's say you move to a different location. There's a lot of people out there who say, oh, it doesn't matter about your mailing location. Look, if you're going to handle the affairs of the state as the attorney, in fact, on behalf of the principal with a fiduciary duty of protecting the estate, you want all the mail matter for the estate going to one location. So if you travel somewhere, you move somewhere permanently, or you're doing an extended stay for a month somewhere else,
I would choose the second one down
and transfer everything to that location for that period of time.
I would use multiple. Yeah. Hold on just a minute. Hold on before you see do the recommended one. I'm changing my mind. Something with multiple notices in the link for that court. There you go. Next. All caps name.
Why is it the all caps name, Smoking Baby?
Oh, they'll make it all caps anyway, but it's all caps name because that's who we're registering.
Again, the reason I'm having him stress that to you is because I'm trying
1,
to
2, 3 Main
get you
Street.
guys to understand that you're not the fucking name. Disassociate yourself with it and create some distance, because a lot of people fail in court. They fail doing banking because they're proclaiming to be the damn name, which carries all the liability. Quit claiming that crap. And it took me a lot of years to get over it. That's why I love my attorney, because I move very efficiently now. When they go, Derrick Gonzalez, I'm the attorney on behalf of the principal here. I'm the attorney in fact. What can I do for you?
Suite
No,
would-
we're looking
the
for
suite
Derrick
would be in the
Gonzalez.
second mail line.
Good luck doing that. That's like trying to tell me where the
The su-
longitude and latitude of the United States exists.
The suite would be in the second line. You could always run it through the USPS and see what it says for the zip code there with the +4. So you do open a new tab with USPS.com. No, the plus. Make it big, click. Hold on. And then do the plus sign next to that tab or Control T. USPS.com. We had a guy had a hard time getting to USPS.com on one call. Freaking aggravating. Oh my God. Should have retarded. USPS.com. Let's see if you remember how to get there. Quick tools. Quick tools. Zip code lookup. Down one.
Yep, one down.
There you go. It says seal of magnifying glass says zip. Yeah. Oh, you got it. It's slow. Find by address. No. It would you're wrong one. Go back to quick tools. Zip code. Oh, you have a zip code by address right there. Or there. Yep, that works too. Find by address.
Now, the other nice thing about doing this is if you end up in
No.
court in a bankruptcy or a foreclosure or
Sweet.
credit card issue, you now can subpoena the federal creditors registry into the case, and it's admissible as evidence before the court. It's a beautiful thing.
Oh, weird. Look at that. STE. See, that's the format they like. The STE 1089. Click the little chevron, point down chevron to the right. To the right. Your mouse is
Little
all over the
down
place.
arrow on the right next to the address.
Her mouse is possessed. Or you just click there.
There it goes.
You're 026. That's your rule route address. Now you have it. So that's the address you would use. You don't need that. You can't copy it. So you would use 2800 STE in the second part of the address on your left one tab over. Do control page up. Do control page up. So now we know the format that's preferred. Go back to the BNC, one tab over. Control page up. Either way. Click the tab or control page up. You can hear me, right? Derrick?
Yeah, I can hear you. She might be having technical issues or difficulties.
Or do a control W.
You can go back to the BNC. It's going to be up there in your right hand top corner of your screen. It says BNC.
Right next to the zip tab.
And we'll finish doing that.
Oh, or control W. You kill this tab. Is she on her phone?
No, it appears to be on our computer.
You're getting closer.
Very top of your screen. Yeah, go back.
There you go. Click. Yeah.
Good job. So at
Yay.
93065, it was
So
zero,
it'd be
zero, right?
yeah. STE 1089 -0700. There was a guy who put in the carrier route address format, and he sent in the form.
Yep.
And he sent in the form. He didn't hear back from him for like 2 weeks. He contacted the bankruptcy court and asked him about. Hey, gave him that little BNC number that's on the bottom of the PDF document, and the clerk there looked it up, and she said, "Oh, we cannot use foreign addresses."
Mhm.
So if you want to get a foreign the foreign grantor trust EIN, whatever, you would use the rule route as the foreign address. Next. You have to fill it out again. Unless you have a PO box or something. What happened?
Uh-oh.
You have to go. You get do-overs. Yeah, it is. It's possessed. This house is not clean. To quote Poltergeist. Make sure the stuff up above is in there.
Looks good.
Simi Valley. Zero.
Okay, let's look at it and review the information, make sure it's all correct.
This is not where your notices. Read the top. This is only your account information, account contact information. Okay. Okay. Scrolly. You got next.
Next.
You do last name, comma, first middle, proper case. Show a distinction.
No, last name, comma.
4 spaces, first, middle, proper case,
No,
Four
4
space.
spaces after the comma.
spaces, 4 spaces.
There's a reason for it. It's how the IRS creates a separation.
Separation. Mhm.
Remember that the American system is all
No, you would only have
symbolism.
you'd only have one. I guess you could have 4 spaces between Melissa and Ann. That works with the
You
the-
just need four spaces between the last name and the first middle. Because your first middle is your Christian appellation. It's your calling. And that's why
Yeah,
they
your Christian
create
name,
the
so 1 space
separation,
between Melissa
because
and
the family came first and then you did. So the first shall become last and the last shall become first. That's
So-
the
So I would just put 1 space between Melissa and Ann.
that's a business name, not necessary.
Well, you should, so because she could go up there, she could put the all caps name and then put Gonzalez, comma Melissa Ann in the care of or attention. That would set a distinction.
Either way.
No, you would do the all caps, not Melissa Ann Gonzalez. Missing an I. ATTN. Like it says. Colon. Control V. Yeah. What's up? It'd be interesting if we put the rule route in there. If you did the rule route there for the individual.
It can always be
Someone
changed
else.
at a later date. I wanted to do it the way that we got it to go through so it doesn't confuse anybody, but later on,
I
they
gotcha.
can just do that
City
again.
Valley. 0700. Next.
I find that most often the processes that are absolutely free yield a great amount of force, weight, and effect in courtrooms and court procedures. This is absolutely free. Doesn't
No,
cost
you would-
a
you-
damn thing to do this.
You would actually type the names. Yes, every name. Every name. And you see that the email address right there, EBNB.
You forgot an S.
SSA. Oh. That's
Oh, she was part of the class yesterday. I may have rubbed off on her. And she's got a potty mouth now. I get sued one of these days for converting people to being cursors. All right.
Bad company.
Yeah, there was somebody in the chat going language, and I was like, I'll work on it. Look
Well,
what
you probably have Melissa A. Period. You probably have Gonzalez Melissa A. Gonzalez Melissa Ann twisted around.
Yep, all caps, be just fine.
Mm-hmm. Why are you little pesky bastards?
Yep. What I want you to do is grab some of your bills that you got laying around your house and look at the all caps name and the way it's spelled. Sometimes it'll be Melissa A, no period Gonzalez. Sometimes it'll be Gonzalez Melissa. Maybe it'll just be M Gonzalez. And that's what you're gonna do. You're gonna keep going through there and putting all the names any corporation, business, or any entity has ever used to build the estate, and you're gonna capture all of those names. If Gonzalez is not your maiden name, you could also capture your maiden name as well. and all the derivatives of the names and how they're spelled. And this is it's important because in the near future, when consolidating the estate and reclaiming your securities and everything, if any business out there has used a derivative of this name, now they're going to know what they're looking for. Okay. Hold on. Go Ann Gonzalez. Go Gonzalez Ann. Go just Melissa Gonzalez. Yep.
Married names, maiden names, blah, 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 blah. The name game.
All you're doing, ladies and gentlemen, when you get to this point is thinking of all the derivatives you've ever seen your name spelled in. So Melissa Gonzalez is one of them. You don't have that one yet? Yeah, you do. Okay. Okay, number 4 you have in number 2 as well. So take the period out. And now that's that. Believe it or not, that period makes a difference. Leave the period on 2. The period on 2 is fine, but that period makes a difference. If you're involved in court cases, when I started buying assumed business names one time in a court to see what they would do, they had at first it was Derrick S. Gonzalez, but it was Derrick S. period Gonzalez. So then I bought the assumed name Derrick S. period Gonzalez. I no more than did that, and a week later, I noticed on the docket they changed it from Derrick S. period Gonzalez to Derrick S. Gonzalez. So I went ahead and I bought that assumed business name, put them on notice of it. Then they changed it to Derrick Gonzalez. Okay, so these are just the little tricks and things that they do. I don't know how much force, weight, and effect it has, but when we start studying Title 31, CFR 357, it talks about the importance of the Treasury being able to instructs us to have all of our names spelled the same on all of our accounts, so everything lines up. And all you're doing here is grabbing all the derivatives, because all these businesses do not have permission to convert or pervert your good name. Where do you buy the fictitious names? It's a good question. That's going to be coming up in another class. I don't know if we're going to have another class in 2 weeks or 3 weeks out here. I'm working on finalizing some processes where I'm at currently. And so as soon as that is complete, we'll have another class. That way I can show you guys the evidence of what has been accomplished. And Melissa, it's important to know that at any time you can always come back here and add names to this and change it. So you don't have to think of everything in its entire capacity. You can always come back and amend this, but this is a great start. Look at that. And evidence of authority will be added. No, you don't. You do not have to click on that one. But later on, if you choose to scroll down. See down, there you go. I am not a third-party processor. I am an authorized third-party processor completing this form on behalf of a client. If you are a third-party processor, an addendum will be added to the end of the form. You are not a third-party processor. Read the top thoroughly. Make sure you understand what you're doing.
Just click next again real quick. I want you to capture that email address that I talked about. Just click next.
No. Next.
Next. Yep, scroll down. Next.
Dustin, you're correct on assume business name and trade name, but there's been a recent discovery that if you want
Next.
to get your trade name or assume business name, it is to do it in the
There.
county instead of with the Secretary of State. And that's why
See
I'm
that-
saying we're going to hold a
see-
class on it as soon as I'm done doing it. We're going to show the benefits of getting
Here's
it.
the checkbox. It says
County versus
EBN at
state.
BAESYS. No, do not click it. Just copy that email address. See, you
Right
see the
there.
email address?
Below the box.
Email to EBN at BAEsystems.com. Copy that email address. Do not check the box. Just
Yep, highlight and copy it. Oh, maybe it won't let her copy it.
something's going on with their system. I don't know. Okay, well, you can write it down. Well, at BAE Systems, so I got it.
Okay.
Okay.
Go ahead and write
Click
it down
next.
because you're gonna need it at the end of this.
I'm pretty sure they give it to you on the paperwork too, but just to make sure.
I believe you're correct on that.
What are you doing? Why are you? These cats are just all over the place.
They must have changed that because I was able to highlight it when I completed.
Yeah. I was too. She might be on a Mac. I don't know. Okay, go to next.
She's writing it down real quick,
Okay.
just in case they don't provide it. Any look, an evidence of authority for related names form will be added to the agreement. That's fantastic. Evidence of authority.
What's that say at the top?
See if you can
Addition.
highlight that web address, the EBN. No, just the EBN one. Copy. Won't let you copy and save it, huh?
Just control. Oh, well, Control C or Max C. Anyway, how many other addresses do you have? Or you could just spend the time making all your addresses one address.
Yeah, if you don't have any
additional
additional
addresses or not.
addresses,
You don't.
it's not an issue.
That W. See what that little instruction says, or that little I next to that header?
At the very top below the red header.
Are other locations at what? No, you don't want to receive notices anyplace else. Okay.
Yeah, no, delete all that.
What?
All right, next.
I'm not a third-party processor.
All
Oh,
right.
print the page, Control P. Just do it for your records. Print the PDF.
You're gonna learn doing processes with Smoking Baby. He is a stickler about keeping a good record. So he's always going to be telling you to print the page and keep it for your records.
Just do BCN, BNC. Just put BNC.
Put BNC National Creditors Registry so you can remember it.
Oh, either way. Yep.
Yep.
Whatever.
Save
descriptors.
every last one of these pages so you have it. Because you want to be able to remember that this is the National Creditors Registry. All right. Yep.
Click. Download agreement.
And I don't know if you can screenshot this page, but that address is important for you. The email address, the USPS address, all that stuff's important.
You can print a PDF as the email address, or you can mail it.
Uh, To complete the submittal process, you must save, print, manually sign, and send the form back to us via email, postal mail, or fax. Now, I walked a guy through this most recently, Pastor of the Way. He was able to sign it digitally, and he just turned around and emailed it, but it says print, sign it manually. So I don't know whether they'll honor his, because they're sticking about following directions.
So you have to scan it. There we go. Now you have to scan it back in. Everything.
Yeah, after you print it and sign it, you scan it back in. So, United States Courts Bankruptcy Notice Center Registration Change of Service. Use this form to add new services or make changes to existing services or accounts. All right. All bankruptcy notices by email containing a link to the notice. So now when they're attaching themselves to the estate or whatever, you're going to get notified of any court matter or anything like that. Scroll down. Now you know if somebody's stealing your identity, you're going to get notified of it.
What was that check? What did the checkbox say under number 1?
Yep. Well, you can't check it. This is print to PDF. You're good.
So you would check that, right?
Except for she's in.
Yeah, but when she does it manually.
Uh-huh.
Type it in there. Scroll down some more.
Thomas, you're able to unmute yourself, buddy.
Thank you. May I ask a quick question?
What's everyone say?
Is this to preempt is this preparatory work when you're going to file bankruptcy? Either chapter 11 or chapter 13 or chapter 7?
I would do it. Yeah.
Okay, I mean it's like amazing because what you're putting up here, I was not aware of it. I've been going through all the B101, B103s, all the schedules for the gentleman, the farmer up on Iowa. So thank you so much for sharing this. I'm going to go ahead.
This
and
is for the
mute
benefit of being able to proclaim being a recognized creditor of the United States on a federal creditors registry, because it is a felony crime to allege to be a creditor of the United States. And now you can prove that you are in fact a creditor. So what happens is when somebody comes in alleging to be a creditor and stating that you're the debtor, your estate's a debtor, you get to say, well, here's the evidence to the contrary that the allegation of the estate being a debtor. And so where is your evidence that you're a creditor, being so you're making the claim on behalf of your principal that you represent? And at that point, it's kind of like Russian roulette for them. They're really screwed.
Well, you can't check it right now. You have to
But
print it
now
out.
if you're going to file a chapter 11 and seeking relief from the bankruptcy court. How would this be applicable getting this set up
Well,
first?
let me
because
ask you a
you're
question.
seeking-
After the class yesterday, why would you ever file for Chapter 11 bankruptcy or bankruptcy in general? Look, 40 statute at large 411 section 7E. I'm the only real party in interest. I'm the grantor. It was a misappropriation of funds. Therefore, I'm allonging and changing the blank endorsement, and I'm going to tell them what to do with the negotiable instrument and the funds. There's no need. Chapter 11 bankruptcy is a commercial thing. It's a business plan. That's why when everybody ragged on Trump for filing bankruptcy 9 times, I go, man, they really don't understand the game of commerce. It's a business move. It's a business play. It's not a bad thing.
This
but
is being done-
in your private capacity don't ever have to file bankruptcy because they owe you an obligation to set off discharge.
So here's the interesting thing. When I did my power of attorney, I
ahead.
didn't mention this. When I was doing the power of attorney, the squiggle for Sean Scott Haggerty is the squiggle. If you could read a squiggle, that would read SEANSCOTTHAGGERTY. That's the squiggle for the all caps name. When I did my certificate of validity, I have a different squiggle for the signature. When I did the signature on the certificate of validity, the squiggle reads MASTERSCOTT, Master Scott. My squiggle as the attorney in fact is a different squiggle than the squiggle for the all caps name. Each one of my capacities, executor, trust protector, guardianship, postmaster, each one of my different capacities has a different squiggle. So that when I'm sitting there ready to do something, I sit there and I think, what capacity am I acting in? So I can make sure I use the proper squiggle. And each one of my squiggles is copywritten as an art mark. So my signatures are copywritten to eco.copyright.gov, along with my fingerprints, retinal scans. Yeah, and all my biometrics are that's the license grantee. So what the squiggle you plan on using as the attorney in fact, you could put Master Ann. You could do that. Master ANN, use your middle name. Master Ann, whatever squiggle that would look like would be the squiggle you would put on that signature where you're going to sign it down there at the bottom, where you would have this squiggle for the who you're acting, because you can't use the all caps name because otherwise you're committing joiner using the all caps name with your with this attorney in fact capacity. That's why the signature gives the office color. The signature is color. Even though it's the same hand, the signature is different, giving color to the capacity. Operating under the color of
You're smoking, baby. You're too far away from your mic. We can't hear you. I don't know if you're using things that are batterized.
Don't worry about it. So the squiggle, the signature you're going to use for attorney in fact would be Master
So
Ann,
scroll down to the bottom.
or you could use Mistress Ann. I don't know if you.
I know what you're looking at. Page 5. It says name and address variations. Your addresses are already up top. You're just doing the name variations. Scrolling down.
Sorry about that. I forget my earbuds not connecting to the
I
microphone.
figured you were connected to earbuds or something because
See this?
it's been pulsing in and out the entire time, but that's all right.
So you would see name of authorized representative. That would be your proper case. That would be the last comma, four spaces, Melissa Ann Gonzalez, comma, 4 spaces, Melissa Ann. The signature there would be your attorney in fact signature. You could use Master Ann or Master Gonzalez, whatever signature you're going to use as the signature when you're acting as attorney in fact would be the same squiggle that you would add here.
Express to her what happened when a judge saw that you signed as Master Scott, and they weren't persnickety about their response to you, but they were very.
Well, the DMV lady, when I signed my driver's license, Master Scott, she said, Master Scott, I like it. Because that the DMV lady actually had some personality all of a sudden.
Yeah.
And
so it's just a way for you to remember the different capacities. What we're doing is helping you establish arm's length and separation from that all caps fucking entity. That is legitimately the biggest struggle people have. They've grown up their entire life hearing this name, and they've grown fond of it, and they can't seem to create the separation. That's my name. Oh, really? How come there's 50 other Melissas out there in the world, or 1,500 other Melissas? Is it really your name?
Attorney, in fact.
It's like when somebody says, "Hey, asshole,"
Small I.
or some asshole hit me in the face. Well, I know I'm an asshole, so am I responsible for the other asshole's actions? No. So does the name asshole belong to me? No, it does not. Am I known to use it? Sure, but who carries the primary active degree of fault for the name asshole? So scroll on down. This is where you'll sign when you print off. You're not going to be able to type anything. And if you don't have a printer now, you can always email this to yourself and print it out later, or go somewhere that has a printer and print it out. And then you're going to sign it, autograph it, review all the information, and then you'll scan it back into a PDF form, and you'll send it off to them. The email response that you'll get back will have an identifying number on it, and that's your receipt that proves that you are now a recognized with a BNC number as being a creditor of
All caps name.
Federal Registry.
The all caps name is the entity. And if you get your power of attorney done, you could also attach your power of attorney certificate of validity and send it in with this document as well. If your power of attorney is done.
And you can always allonge your power of attorney and certificate of validity to this document at a later date. There's nothing that stops you from going back in here later and amending it. Again, it is absolutely 100% free to do this. So any alleged creditor alleging to be the creditor, stating that your estate is the debtor, what is their innocent explanation for not completing a free registry with the National Creditors Registry recognized by the federal government, proclaiming to be a creditor? Well, I'll tell you why they haven't done it. Because to proclaim to be a creditor of the United States and not be a creditor of the United States is a felony. That's why they're not registered for free on the National Creditors Registry. They're proclaiming to be creditors because nobody ever challenges them on that issue. And now you have the evidence that, well, here's mine. I'll show you mine. You show me yours. And they'll never be able to do it. So that's how you get recognized on the Federal National Creditors Registry. There's no more question or debate of whether or not you're a creditor. The estate is a creditor. Never thought about sending it to the credit bureaus, and they're not credit bureaus. They're private for-profit organizations, and they're credit agency, credit reporting agencies. They're not credit bureaus. The very word bureau is distinctively known and associated with government. So if you actually go look up Equifax, TransUnion, Experian, they are not credit bureaus. And I have a class that shows you in 2022, excuse me, how much Equifax, TransUnion, and Experian made in profit for the year in 2022 by selling everybody's private intellectual property and information without our express authorized consent. Equifax made like 4.2 billion. TransUnion made like 3.5 billion. And we're talking profits here, ladies and gentlemen. And Experian was, I think it was around the $4 or $5 billion mark as well. And none of them have the express written consent from you to use that information, and you can go after them for that. You can sue them. I mean, I know a guy that went after him for $30 million. They settled privately outside of court with him. I don't think he got $30 million, but I don't think what they settled with him for was anything to snide at. because they were selling his private intellectual property without his express written consent, and therefore they were slandering and defaming his reputation, which he has a right to, because that's an intangible right. In Title 15, Congress tells us that we have a right to our reputation in Title 15, 1692, where it defines the scope, authority, and the reason that Congress created Title 15, 1692. And it tells you that it leads to marital problem or marital divorce, job loss, invasion of privacy, and damage to your reputation. Okay. And so that's how you can go after Equifax, TransUnion, Experian. If you're requiring Equifax, TransUnion, Experian to send you a credit report, by law, they're required to send you one upon request once a year. Here's the issue. I read everything before I do anything. And as I was reading Equifax, TransUnion, and Experian's little disclaimer in order for you to get your free report from them, in the fine print, it says, you agree not to sue us for any harm, damage, or loss that may have been caused to you. I redlined, vetoed that shit out. Okay. And the reason for that, and you need to let them know that. You need to let them put, either you fill out an affidavit and say, I do not agree to the fact that I'm not dissolving you of any liability. All right. You're obligated per the federal government once a year to send me a free report, and that doesn't dissolve or absolve your liability for printing falsified information that causes harm, damage, and loss to my reputation or the reputation of my consumer, period. So be careful when you go to get those documents from Equifax, TransUnion, Experian. Read the fine print where they try to absolve the liability they have by getting you to enter into a contract and sign and agree that you won't sue them. All right? I'm telling you, look, behind every corporate business, I don't give a fuck if you created your own business and you knew a lot and you didn't hire an attorney. I'm telling you, behind the woodworks of every business, including if you created your own estate and you did your own EIN and you published it in the paper, at some point in time, in some place, there will always be an attorney behind it, because they're brokers negotiating the paperwork going through your business, because that's how the economy works. Securities, bonds, excise taxes, and insurance. And I showed you what money is. It's certificates of indebtedness, bonds, securities, notes, drafts, bills of exchange, bankers acceptance, trade acceptances, letters of credit, ladies and gentlemen, and contracts. Contracts, believe it or not, are money. If you don't believe me, go get a contract with a company. Let's just say, hypothetically, for $10,000. You sign a contract, you agree to perform a service, they're going to give you the 10 grand. You can turn around and take that contract and go to the bank and leverage that contract for an advancement of funds that will be available immediately to you, but you have to sign over your interest in said contract to the bank. Okay? That right there shows you that even a contract, ladies and gentlemen, under the new law is money. All Congress did was redefine what money is, or create what money is. They didn't redefine what the dollar is, because an act doesn't abolish the organic constitution. So I hope this it resonates with you. Never sign a fucking thing without reading it. And if you're gonna sign and you're not gonna do your due diligence, we sign non-assumpsit, without recourse, void where prohibited by law. We really qualify our endorsement to dissolve any liability we may have for failure to do our own due diligence, right? Anybody that's telling you how to sign a document automatically assumes the liability for informing you on how to do so. They tell you, we're not doing business with you if you sign like that. Okay, well, how would you like me to sign? Can you get out a piece of paper and show me how you want me to sign? Just illustrate it for me. I'm really fucking retarded. Illustrate it for me. And then take the piece of paper they signed and go ahead and sign the document the way they want you to sign it. And then you got your evidence that, yeah, this is exactly how he showed me how to sign it. He told me that I need to sign this way. See, because they're giving you legal advice, but they themselves aren't qualified to do that. And they don't realize that by telling you how to sign that contract comes with legal consequences. Every time you affix your wedding signature to something, understand there are legal consequences that are associated with signing your name on the dotted line. Ralph, you had your hand up. Go ahead and unmute yourself, bud. You got a question for Smoking Baby?
First, Derrick, I just gotta say, man, it ain't no words for the appreciation I got for what you do, how you did it, all those hours, man, your passion. Don't nobody do that, man. I haven't seen that, man. So big ups for you. But I just want to ask, can you explain the putting in the claim process?
What kind of claim are you putting in?
For
where are you putting it in?
harm.
What are you talking about? Are you talking about going to the insurance company and making a claim because you've been
No.
caused harm, damage, and loss, and you want them to start a sua sponte investigation?
Yes, for like I got some child support warrants. I mean, not child support, but warrants that's old. Like I put in some paperwork, they leave me alone, really. Like they really just bag off of me, but they still have the warrants on their website. So I want to know how to make a claim because they got all the evidence of their wrongness on the website. Like I had to go to jail and spent 6 hours, never signed anything, didn't take a picture. They end up kicking me out of the jail, like dragging me out. But
Because
I want
they're hypothecating your credit into existence and then stealing the put call, which is the check, which they're calling a warrant. The warrant is a check. It has a monetary value. See, what they're getting us to do is go in there and argue the semantics of the statutes, codes, city ordinances, rules, and regulations. And this is what I did to subvert that. There are no facts in dispute. I waive all benefits without God, and I'm just here to settle the accounting. Who's got the ledger? Who's got the ledgering? Who's bringing forward the security so they can be properly endorsed and negotiated? And we can negotiate who gets what out of the put call, who gets what out of the funds, and make sure that the capital gains taxes are paid so the disputed ownership fund can be paid out to the intended beneficiary. I know I speak like an auctioneer, but if you don't get that shit out of your mouth real quick, they will shut you down because the last thing they want is that shit right there on record because you are standing in that venue honorably, openly admitting that you know that they hypothecated your credit into existence and the cat's out of the bag and they're going to want to shut you down real fast. So to answer your question about making a claim, it depends on what your intent is. If it's an insurance claim predicated on the fact that no real party in interest has made a verified, put a verifiable
general appearance
claim before the court with a sworn affidavit and a statement of facts independently bonding the claim, and you believe none exists, that's how you start that, with the caveat of you have 72 hours to produce, because the fact is, they brought the claim, and if they brought the claim, 72 hours should be more than sufficient to bring all the evidence that needs to be readily available before they ever went before the clerk to get a docket number. Does that make sense?
Gotcha. Yes, sir. Thank you.
Look, I love the Fourth Amendment. I love the Fifth Amendment. I love the Sixth Amendment. I love the Eighth Amendment. Okay. Cruel and unusual punishment shall not be had. When they're falsifying a record to drag you in there to fleece your estate, that's cruel and unusual punishment. It's invasion of privacy. It's identity theft. Now watch, they go identity theft. Well, yeah. Are you going to claim that identity? Because if you don't claim it, I'm claiming it. And any agent and agency willing to claim this identity? Nope. Okay. Well, then it's mine. And yes, I'm telling you, you're engaged in identity theft. Or I'm the attorney, in fact, on behalf of the principal, and you're not authorized to use that shit. Where did you get your authority? Oh, you don't have no authority? I'm going to turn this over to your insurance company. I'm going to hit your bond. Treat everything like a car crash, and then you don't have to go argue in court anymore.
Human trafficking.
Yep, human trafficking, trafficking of persons. It's also the trafficking of children, because what you got to do is disassociate yourself from the name. Child is a term of chattel that can be bought and sold. Your driver's license is a child. It's chattel paperwork. So it's child trafficking, human trafficking, the trafficking of person, false arrest and false imprisonment, when they used a simulated legal process with sham legal pleadings to draw you to a location you didn't wish to be for a duration of time unknown. Oof, that's 2 felonies right there. False arrest and false imprisonment. Do you realize false imprisonment does not require you to put somebody behind 4 walls and close a door? False imprisonment can literally be this. I yell freeze, and you have reasonable probable cause, reasonable articulable suspicion, supported by a reasonable articulable fact to believe that if you moved after I told you to freeze, harm would come upon you, even possibly death. That alone, telling you to freeze and you reasonably believing that if you moved from where I told you not to move from, harm would be thrust upon you. That is false imprisonment. False arrest does not even require you to be touched by another man or woman. Just having a reasonably prudent man being able to deduce that moving or trying to evade or get away from the situation at hand, you would fall prey to some type of harm, is a false arrest and false imprisonment. And it doesn't require any physical bruises to prove the damages that are caused from that.
So if we're filing a claim with like a bank, for example, JP Morgan Chase, are we filing that claim with the FDIC?
Amen, brother. Nailed it. Who was the
Okay.
FDIC created for? Who was the FDIC intended to benefit? We, the
Us.
American people, because what happened in 1933, the Congress got together, the Senate and the House of Representatives, and said, hey, we have a legitimate fear here that the American people will no longer use the banks. We got rid of the state banks. The people believed in the state banks. We took their gold. What is their incentive to do business with this international monetary fund and this central banking system? We fear that we may have caused a panic by allowing this to transpire, because the government was really responsible for this. Remember, when they did the abrogation of the gold clause, they rolled out the National Guard to all the cities at the banks so they could confiscate the gold. They put it out an APB in the form of an executive order by executive order of the Office of the President of the United States, which is really the commander-in-chief, saying anybody caught hoarding gold would be persecuted, facing time in jail and a $10,000 fine. So they took our property while absolutely violating their obligation to uphold the Fourth Amendment, right? The line in the sand, because we have a right to our property. And if they're going to take our property, they have to justly compensate us for it and provide us a reason they took it. They did not do that when they did the abrogation of the gold clause, ladies and gentlemen. It was a strong armed robbery. I'm being very cut, clear, and dry with you. But the reason that I'm accepting of it is because I understand when something of value was given and no performance or consideration was given in return, they're just the holders. They're not the holders in due course. They do not get the rights, titles, and interests that go along with it. They now owe me a duty. They're now trustees of the American people's wealth. And so what did they do? They issued this bill of lading, this birth certificate, this warehouse receipt, this certificate of indebtedness. That's a large debt they owe us, ladies and gentlemen. And amen to that, because what did Congress have to do to ensure that they didn't get hung for high treason for what they had engaged in, which was very much so treasonous? They absolutely, every last one of them, violated their oath. When they took the American people's property under threat, duress, and coercion, vietus arms, to float government so they could do international business to benefit themselves, they absolutely engaged in mixed war against the Constitution and treason. So and guns and nooses and go lynch them up. Well, they said, look, we're going to allow the American people to create the new money. And that new money that they create, notes, drafts, bills of exchange, bankers, acceptances, will be recognized by the comptroller of the currency in the United States Treasury and will be offset and discharged dollar for dollar because we owe them an obligation. Therefore, all property will be vested in the state by virtue of the government. So we, the government, can protect the people's assets from being bought up by the banks, by the bank being able to print up credits in out of thin air into existence and take the assets of the American people. Therefore, the IRS comes into play because they hold the estates where all the credit, okay, is documented. Who's extending credit, who received the credit, who has the tax liability, who does not have the tax liability. Remember, the IRS is not part of the United States. It's not part of the federal government. It is a single and separate entity, and that's why it's located in Puerto Rico. They are outside the scope and authority of the Supreme Court. They have their own jurisdiction, just like the United States Postal Service has its own courts, ladies and gentlemen. The United States Postal Service is a bad mamma jamma. I love the United States Postal Service just like I love the IRS. They are our friends. They are our first line of defense. We put the big demon on the little demon, and the IRS don't give a shit. As soon as somebody says, hey, I gave Watson over here 10 grand, they don't give a fuck whether you gave Watson 10 grand or not. They don't care. Guess what? They don't want to beat on Watson's door because they want their cut. They're going to make him open his books. And if they find even a red cent out of place, guess what? They're going to rip that guy apart. You know, if you got an axe to grind with a judge, just put the IRS on him. That'll teach him. Oh, you want to fuck with me? Hold on. IRS? Yeah, what's up? You're not allowed to have a cell phone in here. Hold on, I'm on the phone with an IRS agent. 1 second. We're just want to make sure you guys have your TIN number. You know, your DUNS number's all good. Your books are in good order. Why? We're audited by the state. No. I'm going to have the IRS come in and audit you guys because I believe you may have hypothecated my credit into existence while engaging in aggravated identity theft without fully disclosing the nature and cause of the transaction here. Yeah, just wait a second. Watch how quickly. Oh, the state doesn't have enough evidence to move forward. We're going to dismiss this.
Then return my instrument. Then return my instrument. I would subpoena the local IRS director into the case. Have subpoena him.
So when I learned that all cases had to be independently bonded, because I'm reading the Fifth Amendment, the Sixth Amendment, the Fourth Amendment, the Eighth Amendment, First Amendment, all that stuff, and I realized that all cases have to be independently bonded, and I'm asking for this bond, and the prosecutor's like, Your Honor, this is insanity. He's trying to stifle this court case and bog it down. Your Honor, I would make a motion. The state would motion to move forward and have a standing objection to his unruliness and asking for visual inspection of the bond. Everybody knows how this works, Your Honor. And the judge is like, sustained. We'll allow it, you know, and standing objection and. Mr. Gonzalez, you're not allowed to mention the fact that you wish to see the bond anymore. The issue's been made and the issue's been ruled upon, and you can appeal if you don't like the court's ruling. The court's ruling, wait a minute, you made that ruling, motherfucker, not the court. The court's a figment of a man's imagination. So this is a thief collaborating with another thief to take credit that otherwise doesn't belong to him without authorization. You just have to have the eyes to see it. As soon as you can see it, the game is over. They need you. You do not need them. And boy, oh boy, when I say they need you, I mean they fucking need you. They need you. They need you to be willfully ignorant. They need you to go along to get along. They need you to be guilty of the mind, mens rea, when they say you violated some benign statute that has absolutely fuck all to do with you. But they need you to go, yeah, Your Honor, you're right. I'll be more careful. No, fuck you. Who the hell are you to lord over me and tell me what I can and can't do? Get the fuck out of here. You must have lost your ever-living motherfucking mind. Think about this. The guy on the side of the road that's accosting you against your will is practicing law on the side of the road, and he's only done 16 weeks of basic training. He don't know shit from Shinola. An attorney goes to the school for 7 years, and I walk all over those fucking asshats. I'm not joking. I got him in there sounding like Porky Pig. And I look at him and go, today, Junior. Well, Your Honor, he's harassing me. tell him to stop looking at me. It turns into a kindergarten thing. Your Honor, he won't stop looking at me. I'm like, yeah, I'm salivating at the mouth because I want a pound of that flesh over there right off your ass, Butch. I remember the first time I beat an attorney in court, I went over there and smacked him on his ass and said, nice game. He got all offensive. Don't you ever disrespect me like that. I go, what? Hey, this is a sport, man. I'm just being a good sport. This is a sporting event. This is a fun game. And what's funny about that is, you know, what are you going to do? Charge me with assault? No, because it's clearly a game. This is a sporting event. And in sporting events, people get slapped on their ass. Good game, Butch. Better luck next time. And I really do shit like that just to annoy them, just to crawl under their skin. I harass, badger, and intimidate the shit out of them. And then after I lose, I'll reach out and try and shake their hand. Good game. Oh, I'm not shaking your hand, you disrespectful punk. I will never shake your hand. That is, everything you did is so unruly. Like I give a fuck about the opinion of a lying, looting, pandering piece of shit who's unjustly enriching himself and his principal in collusion, engaged in RICO, hypothecating credit he's not authorized to do, failing to the nature and cause of the claim, and failing to produce his fucking plaintiff or his warrant of attorney to represent his plaintiff. Fuck out of here if you think that your brash comment is going to hurt my feelings about how I'm a rude, unruly asshole who's disrespectful. Get the fuck out of here. Because all attorneys are lying, looting, pandering pieces of shit. Every last one of them is a lying, looting, pandering piece of shit. They go to sleep with their hand in somebody else's pocket every night. How they sleep comfortably,
Yeah,
I'll never
that's
know.
the truth. They must sleep well at night because they sure hell lie a lot. May I revisit the concept of this National Creditors Registry for just a moment? It looks like you're done talking, so we'll lower your hand in 3 seconds. Oh, okay. The hypothetical situation is a farmer has executed promissory notes to get farm equipment. In doing so, he signed a security agreement. The security agreement shows that they have a right to come in and foreclose, steal the property based upon default. They file a replevin bond, 21 days. So in an effort to stave off the seizure of his farm equipment while he reorganizes, the concept has been put out there to file a Chapter 11 to buy some time so that he can complete a secured party creditor process. And now when you bring forth this National Creditors Registry issue here, which I was not aware of, it seems to me that if you're going to stand on 40 Stat 411 and you're listed in the National Creditors Registry as a creditor, and the party claiming to have a security interest in those notes, when they're called on the mat to actually verify, not validate, verify the debt under pains and penalties of perjury in a bankruptcy setting, it would seem to me that with that classification in the Federal Creditors Registry or the National Creditors Registry, I have two different names here, that once you get in there, you could go into an adversarial proceeding, flip it over as a creditor, and basically put them in a position to prove up their claim. And if they do have a valid claim, then the right to set off is on one side and the right to discharge is on the other side.
So look, we discharge on the public side and we set off on the private side. We're always looking to settle
Correct.
and close the accounts. Settle and close the accounts. What accounts? Accounts payable and accounts receivable. Every court case has an escrow account that is set up. Now, typically, funds are not allowed to be claimed when they're created by us. They're not allowed to be claimed as abandoned for 3 years. But in a court, they provided statutorily that they can claim them after 12 months. What happens with those funds after they're claimed of being abandoned after 12 months, because we didn't demand all rights, titles, interest, dividends, derivatives, debentures, sediments, general tangibles, general intangibles, chattel security, trust residuals, rents, profits, proceeds, futures, and annuities in the chattel paperwork that was generated without our knowledge, because we're not making a claim to be made whole. Okay. What happens after 12 months is they do they claim them as abandoned as a class 5 gift and estate, and then the prosecuting attorney and the Army Corps of Engineers divvy up the funds for future projects in the county, like new lights, new sewers, new bridges, new roads, and they take the funds, because remember, we're under military occupation. Everything that is happening right now goes through the DOD. Everything is under military occupation. And that's where the Libra code comes in. Because the Libra code also supports 40 statute at large 411 section 7E, where it also says the free peaceful inhabitants are to be issued a certificate and are to be left alone. And everything they need out of necessity is to be taken care of. And that is why they issue the certificate. What certificate do you think the Libra Code is talking about? For us
Birth
peaceful
certificate.
inhabitants that can't leave. The birth certificate, ladies and gentlemen. See, I didn't bring that up in the banking class because I didn't want to confuse the shit out of people. Sometimes I can go overboard and people leave with a splitting headache and never want to come back and talk ever again because they're just overwhelmed. But in the Libra Code mirrors exactly what 40 statute at large 411 section 7E. Now, I'm telling you guys, don't just hang off of what I said. I want you guys to all go study 40 statute at large 411 because it is the trust indenture. And once you can express the trust, they have a fiduciary obligation to you. Here's the trust. Are you denying the trust, fiduciary trustee? Are you disclaiming the trust? It's like asking them if they still beat their wives. They can be put up in Guantanamo Bay for disclaiming the trust. They'll lose their position. They'll lose their multi-million-dollar retirement. I'm telling you right now, it is dangerous. Dangerous.
Yeah, the national security issue.
Uh-huh. Yep. And that's why judges lower their head and bow their shoulders when I walk into the room. It's not because I'm the meanest, baddest motherfucking thing in town. It's not. It's the knowledge. It's how much liability do I carry? He doesn't even want money. I asked him what he wanted, and he said, I want your prosecutor, and I want that rogue agent and agency who's operating outside the color of his authority. And he's like, fuck. Well, they're not here. Well, gee, Mr. Obvious, when will they be here? They'll be here tomorrow. I said, good, I'll see you tomorrow. He goes, I won't be here. I said, Steve, I'll see you tomorrow, buddy. Oh, and by the way, I'm going to extend this to you as a courtesy. I handed him his fake oath of office and his delinquent bond that he had on record because he hadn't renewed it. So it means that every case from January to February, March to March, every ruling that he made could absolutely equivocally be overturned without doing anything administratively or judicially, because he doesn't fill the office because he doesn't have the proper oath. He doesn't have the proper bond in place. His bond had lapsed, and therefore he doesn't fill the office. And by not filling the office, I could have went back into all those people that he found guilty and sentenced to jail or prison or whatever. And I could have reversed each and every one of those, because when he was making those decisions, he was not in the proper position to fill that office, which means every last one of those orders is void, not just voidable, but void. And so you guys need to start studying what void judgments are. I don't even need something void. If it is void, it is unconstitutional. It is void from the very inception. It commands no obligation to enforce and no obligation to obey. It is just simply void. No action is required. And because it's void, I can turn around and hit them for identity theft. Look, when they're bringing you into a courtroom with the estate's identity, okay, if they don't have express written permission to bring the estate into the court, that's identity theft. They're taking intellectual property that belongs to the estate without authorization from who? You, the attorney in fact. So in knowing that, to be true, correct, accurate, not misleading, when you look at the prosecutor, you go, hey, where's your plaintiff? Oh, you don't have a plaintiff? Oh, I'm going to go ahead and hit you with identity theft then. I'm going to go ahead and hit you because, look, you can't be dragging me into this venue without a real party and interest. You committed a crime.
Yeah,
You're slandering and
they
defaming
always say it's a state
my
of,
reputation,
yeah.
which I have a right to. You're invading my privacy. You see, I'm not talking about any codes there. I'm just talking about how it is. I don't need any statutes, codes, city ordinances, rules, and regulations to express that. Produce your delegation of authority to use those credentials, or you admit that you're using them without authorization and are liable for doing so to the tune of $25,000 per occurrence.
So now, in regards to setting the foundation as a creditor on the National Creditors Registry, which I find it very funny that it's in the bankruptcy court, because I've been reviewing all the bankruptcy forms and stuff for the Northern District of Iowa, and I never saw that. I've never heard the National Credit Registry. So if the party is coming in and they're going to request or get a stay to go ahead and foreclose on the property, at that point right there, that gives rise to a counterclaim to say you don't have any authority to take that property because you're not in the National Creditors Registry, as well as the fact that this is entitled to do set off pursuant to 40 Stat 411-7E, as per the private side of the bankruptcy rules.
It would be grounds to impeach them because they're non-credible. They made an allegation, which the onus of probandi falls upon them to prove that they're an actual creditor and have standing to bring claim. If they're not a creditor, well, then even if they did have a lien, they falsified a public record either on the county or at the Secretary of State's office. In either case, that's a criminal act. To bring a false,
well, yeah, they filed UCC
claim on a public record is a criminal act.
Yeah, the bank filed UCC ones on the farm equipment, and he's also got some land. But
here's the issue. You're saying farm equipment. Equipment is governed under Title 26. It's different. Equipment is different than private household consumer goods. See, as a farmer, he's registered his ranch or farm under agriculture, which makes him subject to engaging in commerce. Subject because it's a business they're going after. They're not going after the man. They're going after the assets of the business. It's different. Now, if he was just if he had his land and he wasn't registered to do agriculture, because remember, agriculture is commercial. If he was just privately farming for his own benefit and interest, then he could change the tractors from equipment to private household consumer goods that he uses primarily for household purposes. But see, the way that the government structured the agriculture was so they could get their fingers into everybody's property and estates, property and estate. Because remember, they're not taking the land, ladies and gentlemen. They're putting their fingers into what they created, which is real estate and property. They're different than land.
Yep.
And so when this farmer subsidized future FFA, is it H or FHA, Future Farmer of America loan? So kind of like a PPP loan. He agreed to subsidize. You know, the federal government comes in and offers grants and subsidizes their expenses and gives them certain tax breaks, like they don't have to pay a tax on the fuel that they use. It's a red dye diesel fuel. And they don't have to pay certain taxes if they leave certain amount of property as wetlands, or they agree to allow the federal government or state and local governments conduct some funky ass fucking experiment on their property and yada, yada, yada. So what the government did,
well, it's funny.
The farmer couldn't afford to just be a farmer, that he had to engage in agricultural business in order to even survive. And then the GMO, the grain that they're growing now, I mean, you get caught growing seed without buying it, guess what? That's theft of property. You're fucked. You're fucked.
The man has a promissory note or a loan with United States Department of Agriculture through the U.S. National Bank Association, but that loan is not in default. That's paid biannually, and he has his house that's got about $200,000 of equity in it. But these other three promissory notes are in arrears because, you know, all this shit that happened with COVID and everything else, and his business died down. So anyway, I just thought I'd throw that out there. But I want to thank you sincerely for sharing this National Creditors Registry, because he can still claim to be a creditor because his signature is the only one on that those promissory notes.
Well, here's the issue. They never used the promissory notes. They used the application to get the credit, and they whisked away the proper promissory note because he never told them what to do with the promissory note. Take the promissory note that they underwrote and created a certificate of indebtedness, and apply the certificate of indebtedness to accounts payable, accounts receivable, and zero balance the account. Because the truth is, he never authorized the opening of accounts payable and accounts receivable, and those are his accounts. The trustee opened them up purportedly for his benefit, all while failing to disclose that to him, and the trustee's actually being paid by the bank and is doing the bank's bidding, because the bankers are dealers and they deal in negotiable instruments and paper through assignment and transfer of chattel papers for profit and gain. They're brokers and dealers. So you tell them to apply the actual cash value of the over-the-counter security promissory note, because you didn't issue that over-the-counter security promissory note for their benefit to your detriment. And that's exactly what they're doing with it. And the only reason they're getting away with it is because you didn't tell them how to apply your over-the-counter security that's actual cash value, which is recognized by the United States Treasury to be discharged and set off dollar for dollar, zero balancing the account. And if the bank wants to allege that somehow you're engaged in securities fraud, bank fraud, 40 statute of large 411 section 7E says it's full acquittance and discharge. You can't be brought into any court for doing what I'm telling you to do. And you need to be able to stand on that, because I know some people have been drawn into court. They fumbled the ball. They're doing 6 months behind bars. I'm like, how the fuck did you drop the ball? 40 statute at large, 411, section 7E. But it's like Smoking Baby was articulating it to you guys earlier. Okay? If you're just memorizing it and then you're reiterating it, but your heart's not behind it, they're going to run over you. But the judge all of a sudden was shaking in his boots when the man was speaking with conviction. He's like, fuck, he's got it. Damn. Nope, don't want to play with this guy. He's speaking with conviction. He's willing to die on the hill that he stands upon, and that makes you a formidable force, because all the judges are doing is administering the bankruptcy on behalf of the office of the President of the United States. It doesn't matter what man proclaims to be the commander-in-chief or president at the time, because they're operating on behalf of the office of the President of the United States for the benefit of the office of the President of the United States.
Yep. Hey, one more thing. I sent you a few emails, and I called and texted you. What would be the proper method to reach out to you to schedule a private consult, or is that available?
I have a website, selfgovernanceU.com, and people use that to get a hold of me. And then I also have a library. I got about $50,000 invested in that library, and it is a phenomenal library, and people acquire that from the website as well. I'm getting ready to redo and revamp that website. I've been talking to foreigners in a distant land that alleged to know how to do it. And so I'm
What was the
looking
name?
forward-
What was the name of your website again?
It's down there in the chat. It's down there in the chat. So for now, right now, there's not a whole lot on there. I've dropped the ball on that website. I need to get that thing up and running and fixed. But a lot of my prior classes all need revamped. As you heard, Smoking Baby, he created this power of attorney back in 2014, and he's updated it 12 or 20 times now, or a couple dozen times now. We're always evolving. We're always growing. There's never going to be a time where you're going to go, Eureka, I've got it all figured out. It's done. It's over.
Exactly. Yeah. The science is settled. The science is settled.
Right. And there may be a point in time where you're extraordinarily comfortable. I despise the word comfortable, because comfortable means that you've settled and accepted where you're at, and you've let your dreams fall to the wayside. I'm never going to use the word comfortable. Try and stay out of being comfortable. That's a disease. To be comfortable is accepting things the way they are, because you don't believe that you can aspire to be better than you are, or do what you want because of the trying times or whatever. So never fall in the habit of being comfortable. Uncomfortable people make big moves. They do great things. They do big things. So enjoy and relish in the fact that you're uncomfortable.
Hey, Derrick.
The other thing is,
thank you.
I think I'll do another class in another 2 weeks here. And the subject matter will be discharging and setting off debt. We need to do a class on court, and we need to do a class on making a claim against with the insurance company. Let me tell you why it is so much more beneficial to make a claim with the insurance company and submit an affidavit to the insurance company and let them do an investigation than it is for you to try and take people to court. Because in 30 days after making your claim, the insurance company is mandated and required to do a sua sponte investigation to find out whether or not the one that they are surety for, which is the principal, the man or woman, whether or not they trespass on your rights. And they have 30 days to come back with their finding of facts and conclusion as to whether or not you have been violated. Okay. And if they don't come back within 30 days with a conclusion, you can immediately demand that they pay what's due and owing, because they're acquiescing by silence. Okay, you can immediately take them into court and demand that the bond be liquidated by the surety that was created for the benefit of the principal, so he could engage in commerce, right? Or she could engage in commerce to remedy the trespass that you have been subjected to. Okay. When dealing with cops, I'm going to tell you right now, go get their corporate charter for the entity they work for. The corporate charter within the first 3 to 4 paragraphs, I've never seen it not be there, states that they agree to adhere and abide by the state constitution. And the state constitution says right in there that no one shall be accosted against their will, absent a victim, absent a warrant, supported by oath or affirmation. But if they're pulling you over for traffic violations, guess what? They just violated their corporate charter. They're operating outside the scope of their authority. They're operating in their individual capacity, and you can now liquidate their bond. All you need is the surety's name so you can make the claim. And that's why I tell cops, issue the ticket. No, I'm not going to do that. No, dude. You know why I stopped you? Yeah, I was doing 20 miles an hour over the speed limit back there. I failed to use a turn signal, illegal lane change. I wasn't wearing a seatbelt. And they look at me like, what? Yeah, please issue that ticket. No, we're not going to issue that ticket. You want my driver's license, registration, proof of insurance? No, that ain't going to be necessary. Man, I really need a ticket. I'm not going to give you it. You can ask for it all you want. I really want that ticket. It throws them off on their training, because their training is to lord over you. They don't ever expect somebody to be begging for a ticket. Why do you guys think that I begged for that ticket, or I begged to be arrested? Right? I don't beg to be arrested. Let me rephrase that. I tell them that they can do whatever they believe they think they can do. Okay. And that I will offer no resistance. I'm not a physical threat to them. You can do whatever you think you can do. And then they won't issue the ticket. Why? Because I'm going to use that ticket as evidence, and they know it. I need them to issue that ticket so I can prove they stopped me absent a victim, absent a crime. They didn't have reasonable articulable suspicion, reasonable articulable probable cause. They did not supported by a reasonable articulable fact to even engage with me. And that's all I need to make a claim. I just give me a business card. I ain't got one. Well, write your name and number down. I'm not going to do that. I got another call. I got to go. Now, fuck you, dude. Give me something. I'm going to give you an oral warning, fucker. Why am I mad about that? Because he just wasted my fucking time. And then he won't even give me the gratification of giving me a fucking reach around so I can get paid. Because it's really hard to make a claim with the insurance company if I don't have any evidence to support the fact that I had an encounter with the dipshit. And then we also do what's called an electronic surveillance preservation request because we want their camera footage. And my wife's got this nifty little trick. You create an email address that says Buck Naked News. And you send over a nice email from Buck Naked News, an independent news broadcasting journalist organization, an unregistered, unenfranchised news industry. And you send a FOIA request or Freedom of Information Act for that electronic surveillance preservation request for the video footage, audio footage of the traffic stop. And because you're buck naked, buck wild, independent news media, within 24 hours, they will send you that footage. Now, if you're the one that got pulled over and you're demanding it, shit, you might not see that for 3-4 months. The chief of police or the sheriff will say, yeah, we talked to the attorney, and the attorney said that you'll have to subpoena that in court. But when you come out as buck wild, unenfranchised, unregistered, buck wild, buck naked news, under the First Amendment, they have to provide that information from you. They have to provide it to you because they're providing a public service, all right? And the public has a right to be duly informed of their activities because they're funded by the state treasury. They're getting paid through the state treasury, which means when buck wild, unenfranchised, unincorporated, naked news comes forward and makes an email request for the footage, audio, and video, and any other evidence, because we're conducting a news story, they'll send it over to you within 24 hours. And the other benefit to doing that is typically if you're the one that got pulled over, they want to make it $30, $50, $60. Well, if you're buck wild, unfranchised, unincorporated, naked news, it's $1. It'll be $1, sir. Thank you. And most often it's free. So there's a
yeah.
If
Call
they
it
don't,
Betton
it's
Court
probably wasted
News.
use.
I'm telling you right now,
Court
I
News.
learned this stuff because I do what I'm teaching you guys. I'm not just some asshat out here talking out my ass. I actually do this stuff.
Hey, Derrick,
Yes.
you want to tell the W4 story on Labor Day for that farm they were trying to take up there in Nebraska?
The W4 story on
Mellon Bank called him. You don't work for you don't work for Mellon Bank. And he met privately on Labor Day, a deal at the bank. They were trying to foreclose on his farm.
Oh yeah. Yeah, and they met him on a banking holiday, which they're not even supposed to be working.
first. Tell me what he did.
They're trying to foreclose on his property, and we're doing a right of rescission. We're hitting them with the IRS form 1098, 1065. We're filing FinCEN form 8300. We're filing the Federal Reserve form 2046. And then finally, we got to a point where we hit them asking for their W-9 and the W-4. And in the interim of time that it allowed, something had been triggered.
You hit him with a W-4 for the full value of the loan.
That's right. Yes. And in the interim of time, because that was submitted, and it was like, I don't know, it happened pretty quick. I was shocked how quick it happened. But anyway, they called the farmer to meet him.
No, they called Mellon Bank lawyer called up and said, "Who do you guys think you are? You don't work for Mellon Bank. You're going to get in trouble. You're going to get in trouble with the IRS." And we said, well, if we were in trouble with the IRS, they would be calling us, but they're calling you.
Yep.
This is a Mellon Bank attorney from New York calling this guy. And then they set up a meeting on Labor Day, 2021 or 2020, I can't remember now. And they cut a private deal and they didn't take a swim.
Yeah, it was 2020.
Mm-hmm.
It was back in 2020. Yeah, I forgot about that. That was Dave Snelly. Dave Snelly. And it was a nasty fight with the bank. And they were telling him that he was falsifying a record and that he was going to get in trouble. He's not gainfully employed by New York Mellon Bank and yada, 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 yada. And it actually made him nervous. And I was like, what are you nervous for? They're the ones that are engaged in securities fraud, money laundering, being in constructive possession of the funds and the note, or at least they allege to be in constructive funds of the note, and they never distributed the funds, so that's a felony, and it's considered money laundering. And yeah, it was a good time.
Yeah, that's what he's doing. He's getting I told him to go through the 2020 because he got the loan in November of 2020. So go through your 2020, see how much went in, went out, both sides of the column. Go to 2021, both sides of the column on your checking account, all the way through on all 3 loans, get all the numbers together, get your W-4s for those subsequent years on each one of those loans, get your 1040V done, get your cover letter, invoice letter done. And when you stop by the post office, pick up some express mail envelopes, and we're gonna address that this hopefully the next day or two, but we're going to finish the B101 form and the B103 form. And the pastor said, oh, just go buy a bond for the total amount of the fees. And so I don't know if we're going to do that, but it's funny. The
B10 will be $1 unsecured proof of claim against the creditors.
Explain that to them, because I know that's going over some people's head. It took me a minute to understand it.
When people go to bankruptcy, they have to list all their creditors, and then they have to go through. And then what they usually do is they list their creditors on the schedule. They actually put down, $1,000 here, $50,000 there, the mortgage, whatever. They go through and stipulate that they owe it. So instead, when they do the schedule for all the creditors, you just do $1 unsecured, and so when you do your schedule, at some point, all the creditors are supposed to come in and make the claim. If they don't make the claim, and they rely on the schedule that we're making that we're going to admit to, stipulate to it, so they don't have to do a B10 proof of claim affidavit. So then after 21 days, you do a B10 affidavit for each one of the creditors saying $1 unsecured. And if they don't like that, they're going to have to do a counter B10 affidavit with all the proofs supporting whatever claim they're doing. If the creditors don't do their B10 affidavit, then all they get is $1 unsecured. But when they do come in, if they do come in when they do come in with a B10 with all the proofs in it, what they claim is proofs in it, because statements are hearsay, statements aren't proof. When they do come in, now we have battling affidavits, and they cannot walk away. So once you have these creditors locked in with battling B10 affidavits, you turn around and do an adverse complaint within bankruptcy. Bankruptcy is just a civil action, and so you turn around as a cross complainant, as a cross plaintiff against each one of the creditors. And now you get to go after everything they owe you, so the bankrupt has funds to pay everything they owe the alleged creditors, but they're locked in. And then you start hitting them with the 6903 and the SF61 and the W4s, and subpoena all the 1099As and start subpoenaing information FinCEN to see if they're properly registered with FinCEN as a plaintiff in a counterclaim within bankruptcy.
I like it. I know how to get in touch with you, and I know that you like your cat food, so I'll be sure I'm gonna send a half truckload of cat food over for you.
Hey, Derrick, can I share the screen for a minute?
My sister went out to the store. She spent $180 on cat food.
Yeah, I don't know why you wouldn't be able to share a screen. It's unlocked, brother.
So so I went into ECFR, and it is did a search for the entire ECFR.gov, and I typed in attorney in fact to see where else in the federal regulations they talk about attorney in facts, and there are 19. Attorney in fact electing reciprocals. So if there's language in here regarding the attorney in fact, should be added to the power of attorney. If there's any, I haven't gone through them all yet. There's 19 of them. I'm just, whatever. The fact to conduct transactions with the Treasury right here, conduct transactions in my Treasury direct account. There's a power attorney in fact mentioned in there. So there might be requirements, specific language and grants of specific authority as attorney in fact within your power of attorney inside these regulations that we would have to include in our power of attorney.
Nice.
More. There's another page. More. Phil, you do this to have the attorney in fact? Capiche? You guys got it? Can you hear me?
Yeah, we can hear you.
Okay, I'll drop this link into the chat here, everyone. Control V.
But to answer the gentleman's question earlier, he was asking about how do you bring a claim and stuff. You start with a private administrative process. Because I don't care if you're coming in administratively under Maritime Admiralty, dealing with in-rem things, or if you're coming into the judicial side of the judiciary against somebody making a claim that's called against a man or woman that's caused you harm, damage, or loss by way of trespass. We are always supposed to try to settle and resolve the matter privately before we air it in the public. And that's why most often the judges dismiss for failure to state a claim for which relief can be granted because there's been no facts established. There's been no attempt to resolve the issue privately before going public, and no evidence that a private administrative process has happened outside of the public viewing to try and resolve said subject matter. It's real important to understand that the court is actually held on four corners of paper. Court could be at Walmart, court could be at McDonald's. You can have court anywhere. We have court all the time. You just don't even realize it. You enter into contracts all the time because you're having court with friends and family and don't even know it. You're always reaching agreements. I think the grass is too short. No, I think it's too tall. Well, let's settle it a half-inch lower. All right, we can do a half-inch lower. All right, great. You just had court. You didn't even realize it, and you settled your affairs on the private side between you and the neighbor, or whatever it is. You guys do that stuff all the time with your significant others, with your offspring, with your uncles and your aunts and your cousins and your friends. So it's just a matter of being able to see it. See the nature of the relationship and the transactions and be able to articulate it. You always, when corresponding with somebody who's trespass on the estate or against you personally, okay, caused a harm by way of trespass, you always want to notify them of the trespass. That's notice an opportunity. That's part of due process of law, and give them an opportunity to provide remedy. I feel that, your trespass that has caused a harm is valued at $50. I've got the receipt right here from where I had to take the dog to the veterinarian clinic because you hit him with the car or whatever the case may be. And here's a copy of the evidence I have. I got my Ring camera on my door, caught the footage. Well, and the man's like, well, I didn't hit your damn dog. You're like, well, I got the footage here. I'm not trying to argue, just trying to settle this amicably. It's clearly your automobile. And then he starts to look at the footage a little closer. He's like, oh, that's my 16-year-old daughter. And she was on her phone. Shit. What'd you say that bill was again? $50? Yeah, here's 120, I apologize. I'll have to talk with my daughter about how irresponsible that was, sure. But on the other hand, he says, no, I'm not paying you shit. Well, I'm going to give you 10 days to settle up with me. Otherwise, it's going to cause me a hardship and further, it's going to cause me a damage, a harm, and a loss, because now you're absconding from your duty. Your property hurt my property, and you have a responsibility to make right. And he's, I'm not doing that. And okay, well, when I take you to court, I'm just going to be asking for any lawful excuse you feel you may have for not making right the wrong that has transpired. And, we'll let the pieces fall where they may in the court. And you do the caveat in there, your failure to respond, you acquiesce to the following evidence as being true, correct, and accurate, not misleading, including the statement of facts, the affidavit alleged to it, the video evidence supporting it, and now you're establishing the facts on the private side before you ever go to the court. Your Honor, he had 10 days to respond. He didn't respond. He's been avoiding me. I give him another notice and opportunity to settle up with me. Give him an additional 20 days. Notice of fault. He didn't do it. Did a notice of default. Gave him 72 hours to make right. He didn't do that. So then I issued a notice of judgment. Gave him 4 days to cure judgment, and he still didn't respond. I'm just in here to get a summary judgment in my favor. The facts have already been established by his silence being acquiescence. He agrees to all the facts stated herein. As you can clearly see in the caveat, it said your failure to respond timely. You agree to the following facts as stated herein. Just simple. Keep it simple. People like to make it too difficult. I'm guilty of it. I got all this acquired knowledge. I love going in there and making clowns out of attorneys and knowing their craft better than they do. I know they don't write their own documents. I know they use templates out of AM jurisprudence and shit. I know that stuff. I know that my most formidable adversary in most instances when dealing with an attorney is actually the paralegal. They actually do the work. But that's aside from the fact, it's good to keep things simple. Simple claims lead to expedient remedies. So one subject matter, one fact, one verb, one noun, make a claim. Because remember, if you're going to do a multifaceted claim or complaint, well, now you got to prove each element. And then, of course, if you're going to do multiple different suits, but they all pertain to the same instance or whatever, but you don't want to lose one claim because you have them all bundled together and then you lose all claims. And you don't really necessarily understand how to go back and formulate amended pleadings. So you try and make multiple suits out of a scenario. Well, equity will come in and take jurisdiction to avoid a multiplicity of suits, and they'll bundle it all together to get through the process that way. So less is always more when bringing a claim. Be assertive. If you're bringing a claim as a man, don't use statute, code, city ordinances, rules, and regulations. I, a man, have been caused harm by way of trespass, by way of theft of property, by a man who at times acts as an officer of the law that goes by the name of John Doe Smith. That's my claim. That's how I open up and get a docket number. And then I will support my claim with a statement of facts, sworn to under the pains and penalties of perjury, an affidavit sworn to under the pains and penalties of perjury, and I'll give them 30 days to rebut and rebuke the allegations stated therein. And then I'll do the caveat that says your failure to do so, you admit to the following statements of facts, article 1 through 5. Let's say there's five simple statement facts. You unlawfully detained me. You under threat, duress, and coercion, you took my private credentials without authorization. Just simple claims. And if they don't rebut and rebuke, and I'm telling you right now, agents and agency, they don't ever respond. They think they're invincible. Yep. Their attorneys are they've blown so much smoke up these people's asses that, oh, don't worry about that, Bob. And then all of a sudden, look, I've done this to an officer before. They go running to the county attorney. Oh, I need help. What's going on? Oh, he sent some paperwork to my house. Oh, you don't have to answer that. That's all bullshit. 30 days later, he's going back going, can you help me? He's actually got a court case filed now. And he goes, oh, No, unfortunately, I can't do anything with that because he's coming after you personally. He's not coming after you in the capacity of an officer. He's coming after you in your personal capacity. So unfortunately, you have to go hire an attorney. But you said I didn't have to worry about this. Yeah, you probably shouldn't have enlisted that jackass that sold you down the river. That's what happened.
Well, that's exactly what they did in Boris's case and Jimmy's case down in Tampa. They did the same thing what you just said, and the state attorney, a deputy state attorney, came in and coerced the judge to dismiss all the charges that were sent on the private side. And not only that, but they also enlisted and utilized the state attorney generals to write up all of these pleadings for them on the private side. So they were using public funds for a private issue. So Dearborn Jimmy's sitting in the warehouse facility right now. By the way, who's ever got this screen up here on Florida, I've gone through this thing with a fine tooth comb. Go up to 2109. I was born on Florida. If you scroll up to 2109.
I was just letting people know this is in the Florida statutes on power of attorney, where it mentions two, in the presence of two witnesses. Yep. I mean, when you go through, because the Alabama one's the Alabama one, so then you need to go to your whatever state you're in, where you're recording, not filing. You're recording a power of attorney. You're not filing. You file into a case, you record a record. When you record it, you need to go through your statutes in your state, because in Florida, it doesn't require it in the Alabama's power of attorney, but it needs the donor in the presence of two witnesses. This is before the notary. But in Alabama, the donor principal does not need two witnesses. And it goes in here and it has specific language, like in Florida, has specific language required in Florida statutes that's not required in the Uniform Act. So this is one aspect of it. And you want to make sure that the language, there's like specific language that the notary has to use in here. When it's subscribing the witnesses, signing and initialing the notary done in the presence of the principal. The notary writes a statement. Signature or initials affixed by the notary pursuant to this section. Florida statutes has to. So the notary has to do it right also, even though the notary should know what they're doing. But it's good. You don't want to have to redo it again. It's just a pain in the ass, a waste of time. So you want to make sure the notary's on top of what the notary's supposed to do too. Even though you can't tell the notary what to do, you can reference the notary that this is what the statute says here. And because the notary's bond is up for grabs for if they do a bad notarization, you can file a complaint with the Secretary of State against the notary.
Well, the state attorney general Bruce Bartlett was doing it.
Go to your own state statutes, read through the state statutes as well. See what other specific and general grants and specific languages your state requires to have it to be a valid power of attorney.
If you scroll down to 2109, just for a quick second, this is what I used on Florida when I did my revocation of assumed presumed power of attorney. 2109. Scroll up, please.
Power of presumed power of attorney for what? It's a different statute.
For the
being resident agent.
2109.
Termination, suspension, power of attorney.
Yes, correct. It basically says termination, suspension, power of attorney or agent's authority. The principal revokes the power of attorney. That's what I use. And then when you go up, you scroll up here above in the section 458 and 459, that's where it talks about the state registrar, because we found out the state registrar, he said, we don't register births, we register event and issues. And that's where the state registrar, who happens to be a JD, he's licensed as an osteopathic doctor, and he's also wearing the hat as a state registrar. He produces an affidavit saying the principal is incompetent he lacks the capacity to manage property.
That's why that statement over here, I'm competent to handle my affairs, is important.
Yep, exactly. What the
hell? So sunshine statutes. So what was this? What was this thing? What was it about? What's the context?
The context was I did a revocation of assumed presumed power of attorney, and I filed a new power of attorney in Gila County, and I published it in the newspaper for 21 days. Did this back in 2014.
Power of attorney over what?
Excuse me.
Power of attorney over what?
Power of attorney over the trust estate.
What trust estate?
The 109-1957-704035.
The birth certificate.
Correct.
Okay. It has a noun name.
There's
So,
two births. Yeah, there's
Yeah.
two birth certificates. There's one that has just 57, like yours has 63, but there's another one that has a 109-1957-704035. And that one is the one I did the power of attorney over. Because one is properly spelled and the other one is not. It's all capital letters. So it's probably a waste of time with what I know now. But anyway, that's what I used. But I
don't know how
just
you
found
got-
it interesting that
I don't know how you got a misspelled birth certificate.
the birth certificate, the certificate of birth is a all cap letter name. The certificate of live birth has the proper appellation of cap lowercase, cap lowercase, cap lowercase. The birth notification from the hospital with the biometrics and the certificate from the hospital, Tampa General Hospital.
Okay.
Excuse me. Anyway, so yeah, that's what I did. And let's see, so yeah, that's what
Melissa
I did
asked-
back in
Melissa asked me to go.
2000.
What did it do for you? Doing that process.
Well, I used that when I published my treaty document under the peace
What?
document for the House of McFadden.
So what did it accomplish
And-
ultimately? Do you see anything tangible? I mean, it's good to do.
No,
Not poo-pooing it away. Just
no, I haven't seen anything tangible other than the fact that when the guy, I got hit on my bicycle on October 10th of 2023. And so the guy asked me for my driver's license. I didn't have it. I gave him my passport. He went and sat in his car. He rolled down the window. He says, "Would you mind coming over here?" And he says, we have a name of Tom McFadden. And I said, "Well, that's not me." And he says, "Well, did you ever live at this address?" I said, "No, that address doesn't sound familiar to me at all." He says, "Oh, okay. Well, apparently you're not in the system." So, by the way, his name was Mr. Wills, Wills. I thought that very funny. But yeah, so that's happened on October 10th. So I thought that was strange. But
I learned from a pretty intelligent attorney. As much shit as I talk about them, some of them come out of the woodworks and they like to bestow knowledge upon me. And do you know that if you're involved in an accident or a DUI or whatever, and they want to use the fact that the driver's license is suspended, it's not admissible in court and should be immediately stricken from the record if they try to submit any evidence on the record that would allude to the fact that the license is suspended or not valid, and it's inadmissible evidence, and it should be impeached immediately because it would prejudice the alleged defendant. It would prejudice
they put
look,
on Jim's charging
if everybody
documents.
has to have a driver's license, how the fuck is it impeachable alleged evidence, or is it not admissible as to the fact of whether or not he had a license or didn't have a license, or the license was suspended at the time of the accident or the time he got pulled over? And I found that very peculiar. This lawyer was telling me that. He goes, "Yeah, I see a lot of the people that drive without a license or whatever, and then they go into court and they allow the prosecutor to enter on the record that an old DMV record that says that license is suspended or they no longer have an active license or whatever, and that should be impeached immediately because it prejudices them. It's not the subject matter of the scope of the allegation. It has no bearing. I found that to be very interesting.
If someone gets a suspended notice from the DMV, write the DMV back officially and thank them for restoring your right to travel.
I fucking love that. Can I get that with your letterhead on it and an official wet ink signature with an upraised seal? Thank you so much. Thank you so much for restoring my rights. I appreciate that. The restoration of my rights, titles, and interests. Can you give me a full accounting on that account as well, since you've closed it without my authorization? That's fantastic.
Yeah,
I like that.
everything.
Yeah.
The driver's license is W4able too. I'm doing minimum wage 24/7 for the driver's license because I'm always on call for the state to call me up to do that, to occupy that office of driver for the state, since the state it's the state's driver's license and I'm the operator. So the fact that they don't use me doesn't mean that I'm still not hired, because it's tied to the social security number. It's hired 24/7. So
in Jim's case,
yeah,
in Jim's case, real quick, in Jim's case, they put on his charging document and the order of the court that he was a habitual offender of driving on a suspended license. So,
see that's prejudicial. The conclude that
it sure
facts
is
not agreed to, facts not evidence, and facts regard legal determination that I was actually engaged in commercial use of the public roads for private gain for the primary use of the automobile, other than for family household purposes, which is my only intent for using the automobile. You could impeach it that way.
Yeah, they rolled right over all of that.
Conclusion is
rolled,
prejudicial.
they rolled over everything they rolled right over. So it's up on appeals right now. So
it's you just have to object when you're in there, object to it because it's,
or immediately file an interlocutory appeal for your substantive rights being violated, predicated on the fact that there's no injured party making a verified claim, making a general appearance before the court, which you're rightfully entitled to. And do an interlocutory appeal and flush it down the toilet.
Where is it? BNC bankruptcy. Yeah. Someone was asking about my unique ledger numbering system there.
All righty. You got a unique ledgering system you do?
Yeah, that number. Let me find it. POA, power of attorney.
What are you ledgering?
Each one of
Oh, okay. I thought
my documents.
My mind automatically went to negotiable instruments and banking, which is what you're doing with your ledgering system. But yeah, I'm sorry.
So that I mailed a registered mail with a handbag service. That was fun, wasn't it? Handbag service at the post office, so I didn't have to wait. And then that registered mail number was sent to the all caps name. And so you have this registered mail number, and then you have A, that's ledger A, page 6, and line number 2. There's 250 pages in my paper ledger, so that I can have up to 200. It's 3 digits for the page number, and then there's only 28 per page. So I can go into my ledger which is insured. So that the ledger is a list of securities for each one of my documents, and it's a ledger A, page 6, number 2. And that's the ledger. And when I do my ledger, let me find the how I do my 3806.